My lord, kindly to mention a listed matter, my lord. The Jessup appeal, which is listed today, fixed at today at 3:30, my lord. I was to argue today, my lord, on behalf of the petitioners. My lord had permitted me to argue, and Mr. Mehta was to be there. Some difficulty today, my lord. I'll have to leave court at 1. If your lordships either.
Others are there.
Yes, my lord. Yes, my lord, but in my your lordship can hear them. In my appeal, we just had about half an hour submission to make.
We'll see. Let us see, Mr. Thakkar. Yes, with great difficulty we fix matters.
Yes, I know.
So to undo it is again unfair to others also. We'll definitely hear you. Not that we won't hear you, but we are not adjourning the matter.
Please.
My lord, I beg to mention 3 application matters, application for condonation of delay, which should be for inclusion in the list.
Inclusion, just hand over the slip.
My lord, one matter, review application matter of Circuit Bench, Jalpaiguri, my lord.
Circuit Bench?
Yes, my lord. This is judgment delivered by your lordship and Honorable Justice Vishwarup Chaudhary, my lord. The file has arrived, my lord. I've been informed if the bench can be reconstituted for hearing.
Give it.
Appellate side. My lord, appellate side mentioning, my lord. For inclusion, hearing matter.
Original side, court division, near principal item number 1 to 8.
May I please, your lordship?
Why 8 appeals?
Lord, there were 8 different matters, my lord, in which, Lord, the learned judge passed a single order, Lord, disposing of all the 8 applications. But, Lord, what happened that only one appeal was preferred. So, my lord, I sought leave from your lordships to, Lord, prefer the other 7 appeals.
Yes.
Lord, in the process, there is a 17 days delay in respect of the item number 228.
Condoned. Who is appearing for the respondents?
Miller, I will appear for the private respondent. Or
yes, you were there last time also. Mr. Dahiri?
But I am not appearing from any because I have not been allotted the brief.
This is the affidavit
but
of
my lord
service
will
in
pass
respect of
necessary orders because I will not hold back.
GA?
GA number, it's item number 228.
don't record my consent, lordship will
No.
consider.
There's only one GA.
There could be 5.
There are section 5 applications in this 228.
Correct.
Lord, the first appeal is within time. So, Lord, there is no delay in the first appeal.
2 likhun, same order have. This is an application for condonation of delay of 17 days in presenting the appeal. Stop. Causes shown being sufficient, the delay is condoned. Paragraph GA com such and such is disposed of. 2 থেকে 8 same order. এবারে 1টা শুনি আমরা।
Lord, so far as 1 is concerned,
you are not appearing in 1 also.
I mean 1.
Achha.
1 is concerned, my learned friend. My learned friend, Lord, wanted to raise a point of maintainability.
Yes.
So far as the appeal is concerned.
Correct.
So, Lord, I think he should argue first on the question.
But all papers are not there. I can say that. Papers are not there before your lordship.
All papers are not here.
No, because, Lord, we'll file paper book. The appeal has to be heard.
File paper book.
Appeal has to be heard.
If that is so, Mr. Kaur, if you say that the appeal has to be heard, let us give direction for informal paper book.
Correct. Yes. But there only one
point of maintainability can always be raised, Miller.
Only one
even
thing.
after filing.
The appeal is admitted, no? Then if paper books are.
If your lordship, Lord, sees the
I can argue, Miller. I am ready with the matter, Miller.
No there is a direction for the
remand.
Remand. So, Lord, that part only remains to requires to be stayed, and Lord, the appeal can be admitted.
Miller, it's a. As per the IPD rules, Miller, it's virtually allowing the appeal, Miller. If it's a stay, is virtually allowing the appeal.
There can't be a
Miller.
Yes, we are hearing the appeal.
Yes, lordship will hear me. Lordship will hears out the appeal under the IPD rules. Well, I have the rules. All papers should have been annexed. My learned friend hasn't annexed it. That is as per the IPD rules. Because this is an appeal.
Mr. Ghosh, the only thing, rightly or wrongly, the learned judge has remanded the matter.
Yes.
A party has challenged that.
Yes.
We are about to hear the appeal. Now, if before we can dispose of the appeal, the authority acts on the remand and passes an order.
Millard, that is virtually allowing the appeal on the first day.
No, so what you suggest what to do?
Millard, Lordship will keep it, Millard. I have the papers in the Millard first appeal. I have the papers already in the first appeal. Lordship can proceed today, tomorrow, day after. I have the papers ready. I, Millard, thought of it, Millard. I have the papers with me. I can file it here and now. Because a serious maintainability point is there.
The appeal should not be admitted at all.
Millard, kindly have a look at. Kindly
But
have
kindly
a look.
decide the point of maintenance.
Yes, Lordship.
I'm prepared to.
Be admitted at
I'm
all.
prepared to argue out the matter.
Yes, very well. First, Millard, on maintainability, Millard.
Once my lord holds that appeal is maintainable, then comes the question of granting of stay or filing paper book.
Absolutely. No difficulty.
Yes, why is it not maintainable? Tell
Millard,
us.
first of all, it's not a Millard appeal from any Millard civil court order, Millard, or Millard a commercial court order. It's an appeal passed, Millard, on an application whereby, Millard, my opposition to the proceedings has been rejected by the registrar of trademarks or the assistant registrar or deputy registrar of the trademark under the provision just a minute, under the provisions of the Trademarks Act.
You are Dunlop.
I am Millard.
I'm the assignee of.
I am Somitong. I am Somitong, who has acquired the Dunlop. Now, Millard, they come forward and Millard oppose Millard the trademark registration, saying Millard ABCD Millard various grounds were there. Those are on merits. There's an appeal preferred from the order of the registrar of the High Court, Millard, of Millard, the registrar of trademarks to the High Court. So High Court, Millard, is discharging the function of an first appellate court. Now, Millard, that's an appeal under section 91 of Millard, the Trademarks Act, Millard, 1999, a statutory appeal. The appeal, Millard, doesn't provide, Millard, for a second appeal. The statutory appeal, like Millard, doesn't provide an appeal for a provision of like a second appeal, like a section 37 matter. Arbitration and Conciliation Act. There is no provision for a second appeal or a latest patent appeal. The issue Lordship knows is covered by the judgment of Kandla Port, Millard. So second appeal provision is not there. Not only that, Millard, by the way of 2002 amendment, Millard, the Millard Code of Civil Procedure, section 100A, if your Lordship has, Millard.
No, let us first see section 91. Hey,
Yes, kindly have a
Trademark
look at
Act.
section 90.
applicant
I am, Millard, the opponent before the registrar.
তোমরা কিছুতেই আপ টু ডেট থাকতে চাও না, এটা কেউ
91
মাথায় ঘামায় না। 2021-এর বই, এটা 2025। তোমাদের খেয়াল রাখতে হবে, এগুলো প্রত্যেক বছর অ্যামেন্ডমেন্ট হয়।
Kindly have a look at section 21 of the Act. This is the mother procedure. Section 21 is
So
the
who
mother.
was the applicant before the registrar?
My learned friends.
Lord, what had happened?
Yes.
Lord, with the marks, we got it registered, Lord, in respect of certain goods. Then, Lord, we wanted, Lord, expansion of the mark in respect of certain other goods. 8 different varieties of goods. When we applied, Lord, and there was a publication, the Dunlop International, which is now Sumitomo Rubber, came and put their objection. They said that we are the original mark belonged to us, and then, Lord, it was assigned to this Indian company, and therefore they raised various objections. Those objections were rejected, and the mark was registered in respect of 8 different goods.
Against that, they came up
They
before the
came up-
learned single.
May I
To the
Millard, place under section 21.
Challenging the order of the registrar of
Just Millard,
trade.
You are glorious.
I'm glorious.
He's glorious. Now, who is glorious? Lordship is the merits. I'll come to that after when we argue on merits. Millard, kindly take Millard chapter 3 of the Trademarks Act. Application for registration. So, Millard, one has to apply for registration of the mark. Each mark is a separate mark. It's not a question of extension. Millard, may I place Millard 18 first? 18, 21, 91. any person claiming to be the proprietor of a trademark or proposed to be used by him who is desire of registering it shall apply in writing to the register in a prescribed manner for registration of the trademark. So there is a form under which you fill up a date, either it's from 1966 or 1974 or proposed to be used, means you intend to use in that goods, you apply. Below 2, a single application may be made for registration of a trademark for different class of goods and services, fees payable thereof shall be in respect of each class of goods. So below separate application. Now below 3, every application under subsection 1 shall be filed in the office of the trademark registry within whose territorial limits the principal place of India of the business, business in India of the applicant, or the case of the joint applicant, the principal place of business in India of the applicant, whose name in the first mentioned application as having place of business in India is situated. So, Millard, if someone is Millard, there are 4 offices. Now, Millard, 5. Ahmedabad has 1. So, Millard, 5 jurisdictional offices are there. Anyone carrying on a business can Millard go there and file it. Millard, principal place of business. Now, Millard, kindly have a look at 4. Proviso is not important. Subject to the provision of this act, the registrar may refuse the application or accept it absolutely or subject to the amendments, modification, condition, limitation as the case may be. So it's like a show cause hearing. If I apply for a mark, say Kit Kat, the registrar may say, give a show cause notice, asking me to show cause why this application should not be refused or modified or limited in respect of a class of good, because someone else Kit Kat is already there in the Millard market, or this is generic. Like Millard, if I apply apple for fruits, I will not get it because it's generic. It has a direct reference to the character of the goods. I can overcome only by way of use. But apple formula tablets is permissible because it has no reference to goods. So it's on the domain of the register. So Millard, he crosses this stage. In case of refusal or conditional acceptance, subsection 5, of an application, registrar shall record in writing the ground for such refusal or conditional acceptance and the material used by him in arriving at the decision. So, Millard, if a trademark is refused or Millard conditions is imposed, then Millard it also becomes appellable, Millard, before opposition proceedings under section 91. So this is also appellate. Now, Millard, kindly have a look at, we are in 21, opposition proceedings. 20 is important. After a trademark is Millard accepted, it is advertised in the trademark journal, Millard. There is a window, Millard, of 4 months, Millard. Within that window, Millard, one has to file opposition proceedings. That's section 20. Now, Millard, advertisement of the application. When an application for registration of a trademark has been accepted, in this case, it was accepted, whether absolutely or subject to condition or limitation, the registrar shall, as soon as maybe after acceptance, cause the application as accepted together with the condition, limitation, if any, subject to it has been accepted, to be advertised in the prescribed manner, provided the registrar may cause the application to be advised before acceptance if it relates to a trademark under subsection 1. We are not concerned with it. Now kindly take 21. Here, Millard, if it's at the window provided, if I am aggrieved, I can give an opposition. Like Millard, a defendant in a suit. Any person, so Millard, this is the locus, any person under this act, within Millard 4 months from the date of advertisement, like Millard, if it is advertised in 15 January, within Millard 14th of May, or re-advertisement of an application of registration, give notice in writing in the prescribed manner and on payment of such fees as may be prescribed to the Register of Trademark. 2. The registrar shall serve a copy to the notice of the applicant and registration within 2 months from the receipt of the application. Such copy of the notice of motion, the applicant shall send to the register the prescribed manner a counter statement of the grounds on which he relies upon, and if he does not do so, he shall be deemed to have been abandoned the application. So, Miller, procedures are there. If the application sends a counter statement, the registrar serves a copy thereof on the person giving notice of opposition. any evidence upon which the opponent and the applicant may rely upon, submit in the prescribed manner within the time to the registrar, and the registrar shall give an opportunity to them to be heard if they so desire. The registrar shall, after hearing the parties, if so required, here below hearing was given, but below my case is below this was basically an ex parte, and considering the evidence, decide whether the subject to what condition and limitation, if any, the registration is to be permitted, may take into account the ground of objection whether relied upon by the opponent or not. Next, when a person giving a notice of opposition of the applicant sending a counter statement after receipt of the copy neither recites, we are not on that, then 7 is also not necessary. Now, Miller, kindly take 23. Subject to the provisions of section 19, when an application for registration of the trademark has been accepted, either A, application has not been opposed and the time of notice of opposition has expired, like an ex parte suit, Miller. It is registered. Now, Miller, B, the application has been opposed and the opposition has been decided in favor of the applicant. This is, Miller, our case. The registrar shall, unless the central government otherwise directs, register the said trademarks within 18 months from filing of the application, and the trademark, when registered, shall be registered as on the date of making the said application, and the date subject to provision of section 154 to be deemed to be the date of application. Millard, on the registration of the trademark, the registrar shall issue the applicant a certificate prescribed from the registration thereof, sealed with the seal of the trademark registry. So, Millard, this is a registration process. We will fall under 23B. My case is it was an ex parte. I had asked time, it was not granted. So, Millard, we came up by way of an appeal. So, we were not heard. Now, Millard, kindly have a look at section 91. May I place, Millard? Appeals to High Court. Previously, it was IPAB.
Which year's amendment is this?
This, Millard, came in by substituted, Millard, by the Act of 33 of 2021, where Appellate Board was taken up.
This is the problem. We have a
Present.
2021
Tribunals
publication.
Reforms Act is there.
I বইয়ে
Where is your Kaushik? এইগুলো হবে না।
এখানে দিয়ে দাও, এখানে দিয়ে দাও। Some flags are within, Millard. আরেকটা আছে copy. I have 2 copies, Millard.
Yes, please.
এখানে আছে তো correction গুলো সব। Lordship will, my book says, Millard, it's a Tribunals Reforms Act of, Millard, 2021. Millard, previously, Millard, under the 58 Act, everything was in high court. এটা নেই। 17th. I'm sorry.
But kindly look at the Tribunal Reforms Act. I'll hand up.
An appellate forum has now become the High Court. That's really ভালো। তাহলে আমি রাখছি এখানে।
New Appellate Board.
The book, Millard, Lordship will find, Millard, the Appellate Board was, Millard, constituted, Millard, by virtue of, Lordship will find, Millard, this chapter is now omitted. That is, Millard, Appeals chapter 9, Millard, 83 to, Millard, 90 has been omitted. And 92 to, Millard, 96 have been omitted by, Millard, the Tribunal Reforms Act 2021. So, High Court, because Lordship will know those line of cases, civil court jurisdiction is part, those are also taken up. So, what is
21.
omitted is, Millard, 83 to 90, and, Millard, 92 to 96 has been omitted. That is, Millard, IPAB, abolition of IPAB. That is Appellate Board.
Hmm. '92, '93.
Kindly see chapter 16 of the Reforms Act.
Yes, we've got it.
Chapter 16,
Yes, we have
page
got
14.
K, 21K
Yes.
Yes, yes,
substitutes High Court for Appellate Board.
yes,
Then 21L omits 92 and 93.
yes,
Then 94 is amended also.
yes. Again, Miller, 92 to 96 is amended. 92 to 96 is amended. Most important, what is amended is Miller 93.
92 and 93 omitted.
Yes, omitted.
Then why do you say amended?
Oh, omitted. It's omitted.
94 is amended.
Yes.
Again, 95 and 96 are omitted.
Now, Miller, 93 is most important because there was a bar of jurisdiction of courts. So that bar is now omitted. That's Miller substantial for this matter.
So now High Court, yes. Otherwise, accepting that
There is on this score, I don't think High Court is the appellate forum. There is no, there is no problem.
no, what we are saying, apart from that bit of amendment, the section otherwise remains the same.
Otherwise, only the jurisdiction has changed.
Yes,
It has now Miller back to the High Court like the 58.
yes.
Now Miller, kindly take Miller 91. Appeals to High Court. Any person aggrieved by an order or a decision of the registrar under this act or rules made thereunder may prefer an appeal to the High Court within 3 months from the date on which the order or a decision sought to be appealed against is communicated to such persons preferring the appeal. No appeal shall be admitted if it is preferred after the expiry of the specified under subsection 1. Provided that an appeal may be admitted after expiry of the period specified thereof if the appellant satisfy the High Court that he has sufficient cause for preferring within the specified period. An appeal to the High Court shall be in the prescribed form and verified in the manner, etc., etc. So, Miller, this is the statutory appeal. Now, Lordship will find there is no provision in the Act either for a latest patent appeal or for a second appeal, statutory second appeal. It's not there. It's not there. Now, Millard, this is Millard, the constitutional bench judgment সকলে দিয়েছিল অরিজিনাল হলে অ্যাপিল হবে বাট অ্যাপেলেট হলে হবে অ্যাটলিস্ট আমার তাই মনে হচ্ছে জানি না ভুল হতেই পারে 97 হলে অ্যাপিল হবে সেটা
Ghosh, if a statute is silent, Kandla was in the context of Commercial Courts Act.
This is in context of Miller the Trademark Act.
Commercial Courts Act is not silent. Section 13 specifically says, notwithstanding, latest patent is excluded.
I bow down. Miller 10 Miller section 100 capital A of CPC comes into section 100 capital A of the Code of Civil Procedure. Under the IP rules. IP rules. We should become No, আমি আসতে আমি কিছু I'm trying to rectify myself now.
I may adopt this submission.
100A, if your lordship takes of the Code of Civil Procedure, notwithstanding anything contained in letters in any letters patent of any High Court. So, Miller, notwithstanding of letters or any instrument having force of law. So, the instrument can be Miller, the rules Miller, or Miller any other rules Miller, or a document, or Miller anything, or any other law for the timing in force. So, such time Miller, it is there. Where an appeal from an original or appellate decree or his order is heard. So, Miller, decree or order is heard and decided by a single judge of a court. No further appeal shall lie from the said judgment and decree of the single judge. If your lordship reads it again with me, Miller, for the cost of repetition. So this is Millard. May I, Millard, read it because Millard. So latest patent appeal taken away. any instrument, my lord, which provides second appeal taken away, any law for the timing in force means such time when this is in operation. Soft hard copy বার করো, সেখানে বলেছে কমার্শিয়াল কোর্টস অ্যাক্ট will apply. ওই তো ওখানে আছে, আমার কাছে আছে, বার করে রাখো। If I, my lord, read it again, my lord, because this is an ouster, may I say it that way. Notwithstanding anything contained in any latest patent of any high court. So high court gets, my lord, the rule making power under section 129 of the Code of Civil Procedure to make its own rules. And that rules can be, my lord, in divergence with CPC also. But, my lord, this is an exception carved out there. This 100, my lord, is a subsequent amendment. It's, my lord, curtailing the rights. Now, my lord, kindly take, because 129 lordship has to read it, because obviously it will be cited by the other side, my lord. For High Court, it doesn't stop here. Or any instrument having the force of law. So it can be, my lord, a rule-making High Court also. Or any other law for the timing in force. Means such time, this, my lord, 100A is in operation. Where any appeal from an original or appellate decree, it doesn't stop to decree only. Or order is heard and decided by a single judge. No further appeal shall lie from the judgment and decree of such single judge. So it's an, like, my lord, not thereafter in section 34. Or, my lord, cannot be extended beyond 120 days, like order 8. My lord. Now, lordship, kindly have a look at 129. This is the rule-making power of, my lord, the High Court in exercise of its original jurisdiction. The power of High Court to make rules as their original procedure. So, my lord, this is, my lord, in respect of an original procedure. So, lord, appellate procedure is, my lord, 100A, because that is the appeal provision. No second appeal will lie, my lord, 7 except provided. My lord, power of the High Court to make rules as to their original procedure, notwithstanding anything contained in this court. And High Court, not being a court of judicial commissioner, may make rules not inconsistent with the latest patent. Now, if latest patent there is an embargo, can any rule be framed, my lord? If at all framed, my lord, it is can be enforced. Or other, or order, or any other law establishing it to regulate the procedure and exercise of its original civil jurisdiction as it thinks fit, and nothing they herein contain shall affect the validity of such rules in force at the commencement of this court. So, my lord, this relies firstly to the original procedure. Secondly, my lord, it can make rules to regulate its own procedure in ordinary civil jurisdiction. Now, my lord, in the first stage, if you are deciding as an appellate forum under an appellate and under a statutory appeal, this rule-making power, whatever he says, because there is, my lord, my learned friend will of course argue, there is some ambiguity in our rules, my lord, which, my lord, I now want to point. Now, my lord, this has been clarified numerous occasions. There's a Delhi High Court judgment, my lord, which is in favor of my learned friend, my lord. I just say, my lord.
Not one.
The main base judgment, there are others following it. Delhi High Court judgments has an order saying, my lord, there is one order, one judgment, my lord, which, my lord, tries to explain away a celebrated case called Ruby General Hospital, 10F appeal, my lord, lordship knows. 10F appeal, then, my lord, the procedure of that 10F appeal was, my lord, which will be the procedure? single bench or the division bench, or my lord, from single judge appeal will lie. That holds the field. Delhi High Court distinguishes it. Miller and Delhi High Court, the judgment which my learned friend is referring about, there are 2 or 3 of them, Miller. They do not take into consideration the full bench of the earlier Delhi High Court, which constitutes, Miller, 100A, Miller. They do not take into consideration. They rather, Miller, try, Miller, with deepest of respect, Miller, to distinguish, Miller, the full bench of, Miller, the Andhra Pradesh High Court, because Andhra Pradesh was carved out from Tamil Nadu, Miller, the latest patent, Miller, where, Miller, this is quoted, and a constitutional bench of the Supreme Court was cited, saying, Miller, why this 100A came in. Section 100A initially had 2 parts. First part was this, Miller, appellate decree, appellate order. Second part was, Miller, no appeal will lie from the order of the Honorable Single Judge exercising, Miller, Article 226 or 227. That was, Miller, obliterated thereafter. So, Miller, that was considered by Andhra Pradesh full bench. Now, the Delhi High Court says, well, Andhra Pradesh full bench is the Motor Accidents Claim Tribunal, is considering appeal from motor accident, which is a civil court. But admittedly, trademark is not a civil court. Now, Lordship considers the 2 of them. The provisions are the same. It's not a question who is a civil court. It's a question, my lord, High Court in exercise of his original jurisdiction is denuded of his power of entertaining a second appeal or not. Now, my lord, let us, my lord, first have our IP rules, my lord. There is, my lord, but that, my lord, kindly, my lord, takes the IP rules. And of course, Calcutta IP rules, copy the. This came into effect on 2nd July 2024. 2024. 2nd July 2024. Amade rule test. Now, if your lordship takes, my lord, rule 3, definition and interpretation. In these rules, unless context otherwise requires, the act means the Copyright Act, Design Act, Geographical Indication of Goods Registration 1999, Information Technologies Act, Patents Act, Protection of Plant Varieties Farmers Act, Semiconductor Layout, etc., Trademarks Act, and such other acts may be notified from time to time. Now, my lord, kindly have a look at, my lord, D. An appeal, unless otherwise required, shall mean an appeal filed before the High Court under the Act specified under Rule 2A, and the appeals arising out of the proceedings within the meaning of Section 21C4 17 of the Commercial Codes Act. So, 2 parts. First of all, these are the acts. 2A. Millard D. Millard R. Millard appeal. Now, appeal, Millard, has 2 proviso. Either it's an appeal under the statute, under these acts, which is now the statutory, and, Millard, the Commercial Codes Act. So, 2 provisions. Now, Millard, kindly have a look at proceedings. O. The proceedings shall mean and include all original and appellate proceedings originally filed before the High Court and transferred to the High Court consequent to the Tribunal Reforms Act 2001. So, Millard, 3 is, Millard, transferred proceedings from IPAB. Has my lord got it? Now, Millard, all applications and appeals required to be filed before the High Court consequent to the Tribunals Reforms Act 2021, including revocation application. This is how it's classified. This is not a revocation. Cancellation application and other original proceedings and petitions. So, Millard, what is there, Millard? Other original proceedings and petitions and all other proceedings which were hereto maintainable before IPAB under the provisions of the Act of Rule 2A. So, my lord, appeal arising out of the orders mentioned in 3 and 4. Now, which it falls, my lord? First of all, my lord, 3 is out. If we are on 4, it's a construction of 4. Read with section 100. Read with, my lord, rules, my lord, the law of the Supreme Court as framed in Ruby General Hospital and the Constitutional Bench on 100 capital. Now, my lord, if your lordship takes, my lord, 4, all applications and appeal required to be filed before the High Court constitute under the Tribunal Reforms Act, including revocation application, cancellation application, and other original proceedings and petitions and other proceedings which hereto maintainable before the High Court. My lord, appeals arising out of 3 and 4 above. So, my lord, whether an appellate provision, my lord, also, my lord, comes in. Second appeal, my lord, can be preferred in view of, my lord, 4 read with 5. 204 read with 5. This is the only issue. Because if your lordship takes it, reads it, 3 says original IPAB and all appeals and application required to be filed before the High Court. Consequent to the Tribunal Reforms Act, so any appeal to the High Court, including revocation, we are not on revocation. Application, cancellation application, we are not on, because these are High Court's original proceedings. Revocation can be before the registrar, can be before the High Court. Cancellation can be before the registrar, can be before the High Court. Other original proceedings, it's clarifying, and other original and petitions and other proceedings which were maintainable before the High Court. So, strictly speaking, it doesn't make it appealable, subject to correction what falls from it. Otherwise, it would have said, my lord, an order passed by the registrar, my lord, discharging function, my lord, under, my lord, section, my lord. Even if it is said so, my lord, under, my lord, section, subject to correction.
Prior to the 21 amendment,
Yes, lordship.
appeal from registrar's order was to the
IPAB.
board,
To the
IPAB,
board and High Court 226.
right? Now it will be High Court.
Yes, absolutely.
Won't that come under O Roman 4?
My lord, O Roman 4, yes, High Court appeal will come.
If it comes under that, then 5 says appeals arising out of
Which proceeding?
3 and 4.
My lord, kindly take 3, original, appellate and other
We are not
proceedings.
on 3, we are on 4.
Only 4. It's a construction of 4.
Yes.
Only construct.
Why would then
My lord, appellate provision.
talk about appeals arising out of orders mentioned in 3 and 4?
My lord, that
If the order that has been passed by Justice, the learned single judge in this case, is an order under 4,
it's an order under 4. My lord, kindly
it is an
take
order,
under 4.
then it contemplates an appeal
Yes. If
against an order
contemplates
under
an
4.
appeal,
Yes.
subject to the provision of the code. The code is there. It has to be read in subject to the provision of the code.
Yes, but the rules framed by the High Court,
Yes.
for example, original side rules, if there is a conflict, which will prevail?
My lord,
CPC or OS rules?
but my lord, prevail. Like if my lord, if I say in this way, my lord, let's take section 13, my lord, of the Commercial Codes Act. Take section 13 of the Commercial Codes Act.
Correct. Of course, this will prevail.
My lord, kindly take the proceedings. Now, my lord, if it takes Commercial Codes Act, takes the Commercial Codes Act section 13. Will that prevail or will this one prevail? My lord, that is also, my lord, lordship has to read it with 13, because kindly have a look at, my lord. Kindly also have a look at section 30. Is bolche? What does my lord 4 says? And my lord, if 4 says to, in the teeth of this exclusion, my lord, can it be, my lord, meant to contain it's an appeal maintainable?
O defines proceedings. 2O defines proceedings.
Correct.
It includes Roman 4.
Correct.
Which would include an order passed by a learned single judge in exercise of appellate jurisdiction under section 91.
Correct.
And 5,
Makes it
Roman
appealable.
5, contemplates an appeal against an order passed under 4.
Correct. If that is the interpretation, then lordship has to see, my lord, what is the interpretation effect of Millard this
The
100?
possible interpretation.
Possible. Well, we are all Millard
Yes.
arguing Millard. It's not a question of giving a full stop or giving a go by. I never Millard for. Millard, is that Millard what was intended to be Millard? That is Millard. Otherwise, Millard, first of all, Millard, including all original appellate, I read it again, all applications in appeal to be required to be filed by the High Court consequent to the Tribunal Reforms Act. It's a statutory appeal. 91.
Anyway, we have spent a lot of time, Mr. Ghosh. What else do you want to cite?
Sir, I want to cite the judgment.
Cite the judgments.
Kindly, Millard. Kindly, Millard, have a look at.
This will be a second appeal.
কমল দত্তটা দাও, ওটা থেকে শুরু করি। দাও। Millard, this is reported in 2006-7 SCC 613. হ্যাঁ হ্যাঁ স্যার নিশ্চয়ই তো ব্যানারটা বলুন। ব্যানার বলুন। বার করে দাও, বার করে Millard। পেয়ে গেছি 22 and 20। 19
Yes.
Millard, this is Millard. 2007 66 volume 7 SCC 613. Lordship will kindly have a look at. From paragraph 19. টেন এফ টেন এচ টেন এফটা বলে এখান থেকে টেন এফটা appeal lies under the latest patent from a judgment of the single judge of the High Court to the division bench. In this connection, learned counsel placed relied on a decision of such and submitted that the appeal is a vested right and cannot be taken away. Alternatively, the
He put, what are you reading?
The para 19,
19.
19 to 23 is the main.
Yes.
Appeal lies on the latest patent from the judgment of the learned single judge of the High Court to the division bench. In this connection, learned counsel relies on the judgment of this court in in such and such. It cannot a vested right cannot be taken away. Alternative, it was clause 15 does not apply. Appeal lies under for section 483 of the Act. In this connection, Millard, this is such and such is mentioned. Now, Lordship will kindly take placitum E. Against this, the learned senior counsel submitted that Section 10F of the Act came into force on 1991 prior to the application of Section 397 was being filed in the company judge in the High Court. But an amendment of the Act of 31, the power under Section 397, 390 has been given to CLB. Under Section 10E of the Act, the Company Law Board was created. It deals with an application under Section 397 and 98. Therefore, the learned judge has not exercised original jurisdiction. As such, the appeal as contemplated under Section 15, Clause 15 of the latest patent is not maintainable. The learned senior counsel invited our attention to Section 100A of the Code of Civil Procedure, which came into effect from 1/7/2002. This section starts with a non-obstante clause that notwithstanding anything contained in any latest patent for the High Court or any other instrument for the time being in force or other law for the time being in force wherein an appeal from an original or appellate order or decree or heard is decided by a single judge of the High Court, no further appeal shall lie from the judgment and decree of the single judge. Therefore, it was pointed out that in view of the latest amendment of the Code of Civil Procedure, latest patent appeal or intra-court appeal will not lie when the learned judge exercises appellate jurisdiction. In fact, the amendment seems to have been brought on about the recommendation of the Malimat Committee report that the right of appeal should be curtailed only, and only appellate forum should be appellable. Therefore, in view of the recommendation, these amendments were brought in support of the contention learned senior counsel relied on. Now, Millard, one is the Millard. Commercial court will apply এই জায়গাটা বার করে রাখুন। ভুলভাল বলে লাভ নেই। ঠিক আছে, তুমি বসো না, দাঁড়িয়ে আছো তো। হ্যাঁ, চলে ছয় চলে।
Sorry, yes.
We have considered the rival submission of the parties. The first question is that we have to examine whether the appeal against an order of the learned single judge lies on the division bench at the latest patent or not. It may be relevant to mention here that prior to the amendment of the Act, the power under Section 397, 398 used to be exercised by the company judge of the High Court. The appeal against the order of the learned single judge lies under Section 483 of the Act and the division bench. Section 483 reads under follows. So this is Millard. It's Millard. Comes up Millard. And appeals from the order made or decision given after the commencement of the Companies Act, Second Amendment 2002, in the matter of the winding of a company shall lie to the same court to which the same manner which is subject to the same conclusion under which appeal lie or the order or decision second. But after the amendment and power which was exercised under Section 397 of the Act of the learned single judge, the High Court is exercised under CLB under 10E of the Act. The appeal against the order of the CLB lies to the High Court under Section 10F of the Act. Therefore, the position what was obtaining prior to the amendment of 1991 was that any order passed by the learned single judge in exercise of the power under Section 397 and 398 of the Act, the appeal used to lie before the division bench of the High Court. But after the amendment, the power has been given to the CLB, and the appeal was provided under Section 10F of the Act. Thus, Part 1A inserted by the amendment with effect from 1964, but the Constitution of the Company Law Board, the power to decide the application of 397 and 398 was given to the CLB with effect from 31/5/1991, and appeal was provided under Section 10F of the Act of 31/5/1991. Therefore, on reading of Section 10F of the and such of the Act, it is clear that it is a complete code and application under Section 397 and 398 of the Act shall be dealt with the CLB, and the order of the CLB is appellable under Section 10F of the Act before the High Court. No further appeal has been provided against the order of the learned single judge. Mr. Sachin's learned counsel for the respondent submitted that an appeal is a vested right, and therefore clause 15 of the latest patent of the High Court of of the Calcutta High Court, the appellant have a statutory right to prevail irrespective of the fact no appeal has been provided against the order of the learned single judge under the Act. In this connection, learned single judge invited the attention to the score of the court in such and such. Now, Lordship will kindly take Millard, para 22. So far as the general proposition of law in concern, the appeal is a vested right. There is no quarrel with the proposition, but it is clarified that such vested right can be taken away by a subsequent amendment either expressly or by necessary implication. By amending Act of 2020 or 2002 with effect from 1/7/2000 took away the latest patent power of the High Court in the matter of appeal against an order of the learned single judge to the division bench, Section 100 capital A of the Civil Procedure Code reads as under. No further appeal lies in certain cases. Miller, this I have already read. I am not reading it again. Therefore, where an appeal has been decided from an original order by a single judge, no further appeal has been provided. That power which is used to, there would be the latest patent of the High Court has been subsequently withdrawn. The present order which has been passed by the CLP under the CLP and against an appeal which has been provided with the High Court under Section 10F, that is the appeal under the original order. Then, in that case, no further latest patent appeal lie to the division bench or the same High Court. Now, Lordship will kindly take. The amendment has taken away the power of the latest patent in the matter where the single judge hears the appeal from an original order. The original order in the present case was passed by the CLB exercising power under Section 397, 398 of the Act, and the appeal has been preferred under Section 10F of the Act before the High Court. The learned single judge, having passed an order, no further appeal will lie, as the Parliament's in its wisdom has taken away the power. Next, Miller. The learned counsel for the respondent. The learned counsel for the respondent invited our attention to a letter from the law minister. The letter cannot override the statutory provision when the statute is very clear that whenever a statement made by the minister in the floor of the house cannot change the word of the intendment which is grown out from the words, the letter of the law minister cannot be read to interpret the provision of Section 100A. The intendment of the legislation is more clear. In the words, the same has been given the natural meaning and cannot be subject to any statement by the law minister in the communication. The word speaks for themselves. It does not require any further interpretation by any statement in the matter. Therefore, the power of the High Court in exercise of the latest patent in the matter where the single judge has decided an appeal from an original order has been taken away, and it cannot be invoked in the present context. There are no two options in the matter that when CLB exercises power under Section 397 and 398 of the Act, it exercises quasi-judicial power as an original authority. It may not be a court, but it has been all trappings of the court. Therefore, CLB, while exercising a power of the original jurisdiction under 397, 398 of the Act, passed by the order against the appeal to the single judge of the High Court, thereafter no further appeal lies. Now, Lordship will kindly, Millard, omits the two Millard paragraphs, Millard. Kindly, Millard, now, Millard, have a look at paragraph, Millard, 25. In this in this connection, our attention was inward decision of the Bombay High Court in Maharashtra, such and such. In that case, High Court took the view that despite the amendment of 100A of the Civil Procedure Code, order passed by the single judge in appeal arising out of the order of CLB under 397 of the Act lay to the division bench in this connection. Division bench invoked section 4.1 of the Civil Procedure Code, which says that in absence of any specific provision contrary to the code, shall be deemed to limit or otherwise affect the special or local law for the sport of special jurisdiction or power conferred or any form prescribed by or under the law for the time being in force. The division bench concluded latest patent appeal is a statutory appeal and special in enactment. Therefore, appeal shall lie to division bench. We regret to say this is not the correct provision of the law. We have already explained to the facts above that 100A of the Code of Civil Procedure indicate with the power of specifically taken away by the legislature. Therefore, with the view of the matter, Bombay High Court cannot be said to be the correct proposition of law. Now, the constitutional bench. As my lord felt on the lord, my lord, my lord, that High Court can, my lord, by rules section 4, 121, can, my lord, do this, can take contrary view. This was, my lord, argued before the Supreme Court also, my lord. Now, lordship today in our matter has to construe that clause. Whether, my lord, it falls foul of, my lord, paragraph, my lord, 25 of, my lord, Ruby General Hospital, read with the constitution. Because, my lord, my reading, it may not come because proceedings must be, my lord, the original proceedings. Now, appeal is a creature of statute. Statute creates an appeal. What can give, my lord, the second appeal, my lord? The mother, my lord, is the latest patent. Mother appeal. এখন দেখাবো না। Yes, my lord. Just few paragraphs on this, my lord, and I show the constitution. Anything, my lord, query of your lordship, my lord? Lord, there are others.
Subject to hearing, Mr. Kaur. As of now, we find some substance in your argument.
Well, I have the others. Let me complete this chapter. This lordship will
Yes,
complete
yes.
it. If lordship thinks today is the, I am fully ready, my lord. If lordship
very
thinks, my lord, others are waiting, my lord, I am here, my lord, to come any time, my lord, if your lordship.
No, complete.
Because this, my lord, has something, my lord. So I thought, my lord, because now, my lord, kindly have a look at the constitutional bench judgment. No, Mr. Kaur has a judgment of Delhi High Court, 2, my lord, in his favor, my lord. I say, my lord, very candid, 2 of them, but unfortunately.
No, Mr. Ghosh, why don't you just tell us the paragraphs you want to rely upon?
My lord, kindly have a look at paragraph 26.
We'll read it.
26, my lord. My lord, if I place it, I don't have to place, my lord, the full bench, my lord. Otherwise, I have to place. So I took it and indicate the paragraphs from the full bench and the other judgments. I, my lord, thought, my lord, to do it, my lord, this way, my lord.
Very
Subject to
26.
because what is exactly falling, or I do the full bench, because what is exactly, my lord, falling from your lordship, my lord, was the dissenting view in the full bench. The full bench is 5:1 of the Supreme Court. There's a dissenting view, my lord.
Full bench.
Of, my lord, the Supreme Court has a, my lord, constitutional bench or
Constitution bench.
Yes,
Please don't use terms which are forensic.
Kindly, my lord, takes, my lord, the Andhra Pradesh. My lord, in our connection, our attention was invited to the constitution bench in the decision of such and such. In this case, para 26. In this case, constitution bench observed as follows: from section 100 capital A, as inserted in 1976, it is seen that when the legislature wanted to exclude latest patent appeal, it specifically did so. Again, from section 100A, as amended in 2002, it is seen that the legislation has provided specific exclusion. It must be stated that now, by virtue of section 100A, no latest patent appeal would be maintainable in the present case. However, it is an admitted position that the law which would prevail would be at the relevant time. At the relevant time, neither 100A nor section 102 barred latest patent appeal. So, relevant time is the date of enactment of this 2 provision. The word used in the section 100A by way of are not by way of abundant caution. By amendment of the Act of 1976, a specific exclusion is provided. The legislature knew that absence of such words, latest patent appeal would not be barred. The legislation was well aware incorporation is saving in 101, incorporated in section 4 of the CPC. Now a specific exclusion has been done. Now, Millard, similar view has been taken. Millard provides expressly stated would appear from section. Now, Lordship will straight away come to paragraph So Miller, I think Miller, for this judgment, it's not nothing Miller else. Kindly now have a look at. I try to Miller just indicate the paragraphs Miller, nothing more, nothing less. Miller, kindly now have a division বেঞ্চটা দাও কি হলো ওখানে আচ্ছা ঠিক আছে তুমি করো এটা কোথায় গেল বলো তো কথাটা কোথায় গেল দেখতে পাচ্ছ Miller, this is the constitutional bench, Miller. I formally give it to your lordship, Miller. This was part of Ruby General Hospital, Miller. This, Miller, kindly, Miller, takes Miller. I have copy down একটা যদি থাকে একটা আমাকে দাও থেকে দাও না Miller, kindly have a look at paragraphs 20, Miller. Lordship will take Miller, which is relevant are para 27, 32. Then Lordship will now, Miller, there's a minority view, Lordship will take Miller 27 to 32 if your Lordship kindly have a look. Thereafter, there's a minority view, which is from paragraph 77 onwards. And with that, if your Lordship takes Miller 27 to 34 Miller is there. And minority view is Miller paragraph 68 to 72. If your Lordship has a look at paragraph 27, Lordship can take it from 20, 28, 27 may not be necessary, may not be this. Lordship will kindly have a look. 27 to 34 are the relevant paragraphs.
$34.
27 to 34. Thereafter, Millard, Justice Sinha and Justice Hegre's Millard dissenting view is thereafter, Millard. So the Millard, the majority view is Millard from paragraph 27 to 34. And thereafter, there's a dissenting.
Yes.
So Millard, it says Millard, what is the implication of Millard, this act? Now, if your Lordship takes the next one, I just indicate the paragraphs. I don't want to read it. Millard, kindly, United Insurance, Delhi judgment, Insurance United. দেখিও না না তারপর দাঁড়াও বেনুগোপালটা দাও প্যারাটা দিয়ে দাও Millard, next I give a judgment of the very recent view Millard, which follows Millard this judgment on Millard 104. I just indicate the paragraphs. I'm not placing it. দাও এনেছো চটচট করে দাও জজ সাহেব বলেছে kindly have a look at para 18 Millard 2017 4 SCC 723 paragraph 18.
Paragraph?
Kindly have a look at paragraph 14 Millard, if your Lordship takes 14. Or Millard, Millard's para 10 has Millard that Millard 100A quoted. What was 100A Millard originally and what was Millard after Millard 2002 amendment, that is there in paragraph 10 and read with paragraph 12. The Lordship will straight away then come to paragraph and paragraph 15 Millard. So it reiterates Millard the whole view on the maintainability of the asset. Paragraph 15 LPA was dismissed. Now Millard, let us Millard show Millard the full bench. আর কিছু নেই তো ঠিক আছে আর সন্তাপানটাও তো দেখিয়ে দিয়েছি তাই না দেখিয়ে দিলাম তো সন্তাপান দেখি kindly have a look at the full bench of Millard the Telangana High Court Millard which was carved out from Madras, so Millard they also have a latest bit and now I reading it I know the copy ta ha ganda panda 3 bench ta 5 bench ta 5 bench ta আমি দিলে তো সব দেখাবো না ঠিক আছে স্যার ছেড়ে দাও এটা দেখি লাভ কি আছে Yes. Kindly have a look at the Delhi High Court's Millard. Delhi High Court scaled in Avtar Narayan full bench. Delhi has a full bench Millard which is not considered in the subsequent judgment. This is the case of Avtar Narayan well. Sir, copy though. This is Millard ILR 2009 Delhi 411. Kindly have a look at paragraph 4 if your lordship has a look at paragraph 4. Delhi High Courts Millard they also have a power now. They are not latest patent. 5 is Millard 100 capital A. Before rules to have that moment. Then straight away lordship will come to paragraph 12 Millard, where Kellingworth Hotel Millard, which says Millard statutory appeal by your act and rules, you cannot give a special. That's special appeal Millard to Millard, a second appeal Millard. To the case para 12 is Kenilworth Hotel. I'm just indicating, otherwise it will take unnecessary time. Millard. Then we straight away come to paragraph 18 and 19. Also Millard, most important Millard is Millard New Kellingworth Hotel. Para 17 is all the Millard Supreme Court judgments. Kellingworth Hotel and Millard RPS Sampath are all there Millard. Now Millard in one stray Millard observation was there in the Supreme Court in the Sarda Devi's case versus State of Bihar. Like latest patent is akin same with the Constitution. That Supreme Court says no nothing. That's not the correct proposition. That Millard paragraph 17 and 18 is Millard what the Supreme Court felt and 19 Millard is on the discussional law. Now with this lordship now Millard, I just end my submission, takes the rules once more with me Millard. Can it mean Millard the appeal a second appeal provided by the rules Millard, reading Millard with this judgment with our rules? It's a original proceedings Millard, rectification, cancellation, everything, but appellate provision, no.
22. What's it?
Heavy full bench টা দেখায় নাকি? If your lordship Miller now comes to
Yes.
your lordship now takes the rules once more. This is what troubling me, troubling your lordship, troubling everybody. That's 4 and 5. If lordship takes it again, could it be Millard a second appeal provided by this Millard small window of this rules Millard in view of what is laid down Millard by this starting from the constitutional bench? Because Millard, it says all applications and appeals required to be filed before the High Court consequent to the Tribunal Reforms Act. So
Yes.
Tribunal Reforms Act Miller gives a provision for appeal, a statutory appeal only. It doesn't give any second appeal. If it had given, naturally.
And also there are several acts
Yes.
which are covered by these rules. Maybe there's some statutory second appeal in some act, we don't know.
I bow down, Miller, including revocation application. So Miller, rule makers are conscious. Revocation is before the High Court, original proceedings. Cancellation application, High Court, original proceeding. Obviously, Miller, 91 appeal is there. And other original proceedings and petitions. So Miller must be connected there too. Petitions must be connected to either cancellation, revocation, cancellation, and other original proceedings, and other proceedings which were maintainable before the IPAB as defined under 2A. So if IPAB itself was discharging Miller the appellate function, and you discharge a appellate function, second appeal will not lie.
That's it,
These are by respectful submission.
Mr. Kaur.
Just supplement. Just supplement. Adopt the entire arguments, but the only thing, my lord, what is troubling, my lord, is O5. What is proceedings? Now, my lord, kindly takes 97 of the Trademarks Act. What is left out of the Tribunals Reform Act of the after the Tribunals Reforms Act, what is left in the Trademarks Act are section 91, 97, 98, and 99 and to 100 are added. I will kindly seize procedure for application for rectification before High Court. But this is an original application. This is not an appellate provision. So this, under this, appeal will lie before the division bench. I think that is contemplated by this. And my lord, O says appeals arising out of the orders mentioned in 4 and 5. So it must contemplate an appeal. It doesn't provide that is any order from a 91 is an appellate order. So if that is so, if second appeal from an appellate order is a bar, my lord, this is not maintainable. They have to go to Supreme Court.
All right.
But this is only through supplement, my lord, on O.
Yes, Mr. Kaur.
May I start with section 100A of the Code of Civil Procedure? Lordships will not kindly take. May I just place section 100A? Says, notwithstanding anything contained in any letters patent for any high court or in any other instrument having the force of law or any other law for the time being in force, where an appeal from an original or appellate decree or order is heard and decided by a single judge of a high court no further appeal shall lie from the judgment and decree of such single judge. Now, my lord, both decree and order is, my lord, defined in the CPC itself. If your lordships kindly come to section 2, subsection 2, your lordships will find that section 2, subsection 2 says that, Lord, the decree is a decree of a civil court. Order also is an order of a civil court. Now, Lord, the order is defined in section 2, subsection 14. Now, Lord, what are we concerned with? We are concerned with an appeal from an order of a registrar, who is an executive authority. The order passed by the registrar can never be an order as contemplated under section 100, subsection A. Lord, all these judgments that my learned friend has cited, Lord, you kindly sees, Lord, where clause 15 of the latest patent is omitted. Clause 15 of latest patent has been omitted in case of an appeal from an original decree or an order which is heard and decided. So, Lord, we are concerned here with not any decree or order passed by a court which is equivalent to a civil court. Lord, the first judgment, that Ruby Hospital's judgment, which is cited by my learned friend, there, under section 483 of the Companies Act, Lordship remembers there was an appeal from an order of a learned single judge. Lord, that was amended. And Lord, the function of a learned single judge was taken away and given to the Company Law Board. So it was High Court's function and jurisdiction which was being exercised by the Company Law Board. And from the Company Law Board's order, there was an appeal under section 10F. And my lord, the order of the Company Law Board was considered to be an order of a civil court. And that's why, my lord, clause 15 was read to have been excluded. And therefore, the Supreme Court, my lord, considered that in the Ruby General Hospital. And that has been followed in other cases where, my lord, the order itself is order of a civil judge. If your lordship sees the, my lord, last judgment which was cited by my learned friend, ILR 2009 to Delhi, page 411. Your lordships may kindly see the first paragraph. My lord will find that the district judge passed an order from which an appeal was taken to the High Court, first appeal, and against that, a second appeal would lie or not in the High Court. That was the consideration in ILR 10. Where, my lord, the Ruby Hospital's judgment is considered, and my lord, also the other matter where the similar thing had happened. Now, my lord, kindly, my lord, have a look at.
Or can it at all be treated to be an appeal under clause 15 of the latest patent? Because even if latest patent apply, even if it applies, the court which passes the order again, which has passed the order against which you have come up in appeal, that should be a court exercising original jurisdiction.
Yes.
Under the Act, it is exercising appellate jurisdiction.
Lord, kindly consider the rules now. That is the reason, Lord, why I wanted to place the rules, because my learned friend stopped at the definition. But there are something more in the rules itself. Kindly, Lord, have a look at the rules. Lord, the issue is, Lord, in which division this power is exercised. Kindly, Lord, come to, Lord, Rule 4 first. Rule 4. Kindly see intellectual property right division. Has your lordship found that? There shall be a division in the High Court to be known as intellectual property right division, hereinafter referred to IPRD, having 2 or more benches consist of single judges for the purpose of exercising the jurisdiction and powers conferred under these rules. Then Lord the Chief Justice, I skip that. Please come to C. The IPRD, before that B, the Chief Justice shall nominate such number of judges of the High Court as may be necessary to preside over IPRD. Such judges shall preferably have experience in dealing with intellectual property subject to the matter. Then IPRD shall have exclusive jurisdiction over all intellectual property subject matter proceedings. Lord, it is defined as intellectual property subject matter proceedings required to be heard by a single judge, including then Lord, all transferred IPAB proceedings, all intellectual property subject matter proceedings pending in the High Court, then all intellectual property, this is important, subject matter proceedings filed after the effective date, except those required to be heard before a division. And then Lord, all intellectual property subject matter proceedings required to be heard by a single judge shall be transferred to IPRD. Then Lord 5. Intellectual property right appellate division. There shall be an appellate division in the High Court to be known as intellectual property right appellate division. Then Lord, please come to D. IPRAD shall hear all appeals against orders passed by IPRD. So Lord, what is done under the rules is that the applications which are filed, they are not treated as appeals. They are treated as applications filed under the intellectual property right division. And Lord, this is treated as an application filed under the intellectual property right division with a subject of right of appeal to the intellectual property right division bench. So Lord, these are treated as commercial matters under the intellectual property right division, and Lord, from the division there is a right of appeal. And your lordships will kindly see Lord definition of proceedings and also the acts under which this can be filed. One of the act is Trademarks Act, and the proceedings are also defined. And your lordships have rightly pointed out Roman 4. These are the proceedings, but proceedings are under the intellectual property right division. Lord, kindly consider this. One requires a decree or an order which is contemplated under section 100A for the purpose of exclusion of clause 15. But we need not go to clause 15 here because right of appeal has been preserved under the rules itself.
No. This is where appeal lies.
Yes. And Lord, your lordships had rightly pointed out at the beginning of the hearing, kindly see clause section 13 of the Commercial Courts Act also. There also Lord, your lordships will find commercial division of a High Court. The expression commercial division has been, Lord, really carried here as intellectual property right division. And 13(1)(a), your lordships will find any person aggrieved by judgment and order of a commercial court at the level of district judge expressing original civil jurisdiction, or as the case may be, commercial division of a high court may appeal, etc. So, my lord, today the situation is that there is a intellectual property right division from which an appeal is provided to the division bench dealing with, Lord, the intellectual property right. And Lord, so far as commercial division also, the same thing. Under the commercial division, any application filed is also appealable. Now, Lord, this issue was considered by the division bench of the Delhi High Court. 2023. Look, this is reported in 2023 SCC Online Delhi 5531. Don't see the judge's name.
Did this consider the full bench judgment of Justice A.P. Shah?
Everything.
Everything.
All judgments have been considered. And Lord, this is one of the well-considered judgment, I thought, because where, Lord, the provisions are taken note of. Kindly come to paragraph 16. Then, Lord, from paragraph 68 onwards.
Paragraph 16, you said.
1-6 first. This is page 22. The pagination is at the top left hand. Lord, paragraph 40. Kindly, Lord, come to paragraph 40. These are the judgments which are noted. Your lordships may kindly come to paragraph 40. This is 2000. Paragraph 40, Lord, the table will show, Lord, what are the judgments which are considered. Then, Lord, at page 40, your lordships will find the sections which are considered. Then, Lord, please come to paragraph 44. Lord, the judgment notes, Lord, under the Trademark Act, the provisions of appeal. After considering, Lord, all these judgments in detail, from paragraph 68, your lordships will find the discussion starts.
Is it-
Is 68. paragraph 68 onwards, your lordships will find that discussion starts from paragraph 68 onwards. Says the position may be summarized thus: from the various judgments which have been cited for our consideration and have been noticed herein above, those which had recognized section 100A of the code as a barring the avenue of an appeal which may otherwise be available in terms of the latest patent provisions, either originated from the orders of the judgment passed by the civil court, or where it was the civil court which formed the principal tier of the adjudication, although it may have been exercising a jurisdiction otherwise conferred by a special enactment. Insofar as the judgments of Gandla, etc., are concerned, those full benches had arisen from matters which had originally placed before the Motor Accident Claims Tribunal. Insofar as the position of Motor Accident Claims Tribunal is concerned, we find that in Nahar Enterprise, India Industrial Enterprise, it has been doubted whether such a tribunal could be placed on the same pedestal as a civil court. In the aforesaid decision, the Supreme Court had further held that debts recovery tribunal would also not be liable to be recognized as a civil court. All that can possibly be said in respect of a motor accident claim tribunal is the deeming provision which are incorporated in the Motor Vehicles Act, which confers on them the powers of civil court, albeit for the limited purposes specified therein. However, it is apparent that none of the decisions which were cited for our consideration appear to have been taken note of the definition of the words decree or order as appearing in the code. The words decree has been defined in section so and so, means the formal expression of the adjudication by a court, which conclusively determines the right of parties. Section 214 of the code proceeds to define the word order to mean the formal expression of any decision of a civil court which is not a decree. Although the phrase civil court is not specifically defined, one can safely discern the meaning liable to be ascribed to it from section 24 of the said code, which while defining the word district refers to the local limits. Undoubtedly, therefore, the word order, wherever occurring in the code, would have to be understood bearing in mind section 214 of the code. Section 100A of the code prescribes the filing of a further appeal from a decision rendered by the single judge of a high court, where such single judge was hearing an appeal from an original or appellate decree or order. It would thus appear to mean that where a single judge of a high court has considered an appeal arising from an original or appellate decree or order, no further appeal would lie. The restraint on a further appeal being available to be preferred is to operate notwithstanding anything contained in the latest patent of a high court or any other law for the time being in force. However, we find that when section 100A of the code speaks of an original appellate decree or order, it has to be necessarily be understood in light of section 214 of the code, which is unambiguous terms defines it to mean an order other than a decree which amounts to a formal expression of a decision of a civil court. As we construe section 100A of the code, it would appear to bar a second appeal only in a situation where a single judge had heard an appeal from a decree or order as defined in the code. Kamal Kumar Datto had found that the Company Law Board had all the trappings of a court, and that consequently section 100A of the code barring a further appeal in terms of the latest patent. The full bench of the Andhra Pradesh High Court in Gandla, etc., failed to notice that the Motor Accidents Claim Tribunal is not a civil court, as also 100A of the code, and that the bar of a further appeal is as construed in terms thereof would apply to the decree or order as defined by the code. The larger bench of Andhra Pradesh in United Insurance, while concluding section 100A of the code could not be read as restricting a right of appeal only to matters arising under the code, also failed to either notice or consider section 214 of the code. The decision in Muhammad Saud so and so arose from the matters which had been originally placed before the civil court. Then, Lord, I'm sorry, Lord. But please look at paragraph 74 and 77. Reverting then to the facts which obtained in these appeals, we find that undisputedly the Registrar of Trademark is not a civil court, even though some of the powers that are otherwise available with a civil court may be placed in its hand and be exercised by it, but the same would not make it a civil court. We have no hesitation in holding that it would not qualify the test of trappings of a court in the light of the decision of Anglo-French Drug Company and Khode Distillery. Section 91 of 1999 TM Act does not prescribe the appellate remedy to be governed by the provisions of the code. This, as we have found above, is a departure from section 76 of 1940 TM Act and section 109 of the 1958 TM Act, as well as section 299 of the Indian Succession Act 1925, on the basis of which full bench came to rule and decide Avtar Narayan Behal. All of the above would tend to indicate that LPA against an order passed by a single judge while exercising section 91 power would not be barred. Then Lord 77, we would think that the intent of section 100A would be confined to a second appeal when preferred against a judgment of a single judge exercising appellate powers, provided it pertain to a decree or order as defined by the court. The bar would thus only operate where the decree or order against which the appeal was preferred before the single judge was of a civil court. We further note that section 214 uses the expression civil court and not court. It would thus be doubtful whether the trappings of a court test as generally formulated would have any application. However, even if we were to proceed on the basis that such a test could be justifiably invoked for the purpose of section 100A, the Registrar of Trademark would not qualify the standards as enunciated. Now, Lord, please come to paragraph 44 once, because all these sections are analyzed in a table in paragraph 44. Your Lordships will find that insofar as 1940 Act is concerned, which is the first act, if your Lordship turns the page, please come to subparagraph 3. I'm sorry, the subsection 3. It says, subject to the provisions of this act and the rules made therein, the provisions of the Code of Civil Procedure shall apply to appeals before a high court under the act. Similarly, Lord, if your Lordships look at the 1958 Act, there also your Lordships will find in subsection 8. Has your Lordship found that? But there is a departure insofar as the Trademarks Act 1999 is concerned. Kindly see section 91. In fact, this chart gives, Lord, how the provisions of the Trademark Act has been made differently by the legislature. Because, Lord, the earlier two acts, the proceedings were not taken to be akin to proceedings under the Civil Procedure Code, which is not there in the 1993 Act, 1999 Act. Now, Lord,
Yes.
there are two things. Lord, my learned friend's argument not only, Lord, goes contrary to section 100 subsection A, 100 capital A, but also his argument, if it's to be accepted, Lord, it has to, Lord, go contrary to the rules framed by this honorable court under the intellectual property, Lord, this intellectual property rights division rules. So, Lord, there are existing rules, and also clause 15 is not barred. So, Lord, one can't say that the High Court was not within its jurisdiction to frame the rule. And in any event, vires of these rules are not under challenge as of today. So, Lord, the rules are absolutely governing the field. and it clarifies that any order passed by the Intellectual Property Rights Division in exercise of jurisdiction under the Intellectual Property Right Division is appealable. And there is no exception made. And in fact, it says all intellectual property subject matter proceedings filed after the effective date, except those required to be heard before a division bench.
Yes.
And Lord, there is one other judgment, Lord, of the Delhi High Court, also, Lord.
Mm. Correct. Yes.
Lord, kindly come to paragraph 98 onwards. Lord, after the various judgments are considered, please come to 109 onwards. But the issue is, Lord, whether these in chartered high courts, Lord, where these provisions are there, the other high courts are entertaining, Lord, appeal, or they are also, Lord, rejecting these appeals, and Lord, you have to go to the Supreme Court. Lord, at least from Delhi High Court judgments, I find that Delhi High Court is entertaining appeals. And Lord, in these two judgments, I have not found a similar rule as the rule that we have framed in the that intellectual property right division rules. At least I have not come across this having been referred in the judgment. Now, Lord, please come to paragraph 9, 110.
Yes.
110, Lord. Likewise, in a decision qua a rectification application preferred under section 56 under the 1958 Act, an appeal lay under section 109 of the Act with a single judge of the High Court, and a further appeal could be preferred to the division bench from a decision.
Correct. Yes.
From a decision rendered by the single judge. The 1999 unamended TM Act also provided an appeal to IPAB from a decision rendered on rectification application by a registrar under section 57. Then 113, it appears that the provision of an intercourt appeal, which stood incorporated in subsection 5 of 109 of 1958 Act, was perhaps a consequence of a decision rendered by the Supreme Court in National Swing Thread case, where one of the issues which arose for consideration was whether an intercourt appeal lay under clause 15 of the latest patent from a decision rendered by a single judge under section 76 of the 1940 TM Act. As indicated above, section 76 of the 1940 TM Act vested a right in the person aggrieved to prefer an appeal with the High Court inter alia qua decision rendered on his rectification application. The Supreme Court ruled quite emphatically that an intracourt appeal would lie against a decision rendered by a single judge under clause 15 of the latest patent, which is parameter to clause 10 of the latest patent of the Lahore High Court. To be noted, in National Swing Threads case, the decision of the single judge under section 76 of the 1940 Act was rendered in the context of an application for opposition filed by the respondent in that case with respects to an application for registration of a trademark which was deceptively similar to the respondent's trademark. In this backdrop, the following opposite observations were made by the court. The appellants preferred an appeal against the order of the registrar of the High Court of Bombay as permitted by the provisions of section 76 of the Trademarks Act. Mr. Justice Shah allowed the appeal, set aside the order of the registrar, and directed the registrar to register the mark of the appellants as a trademark. From the judgment of Mr. Justice Shah, an appeal was preferred by the respondents under clause 15 of the latest patent of the Bombay High Court. The appeal was allowed, and the order of the registrar was restored with the cost throughout. Hence the appeal. In our judgment, both the questions canvassed in this appeal admit of an easy answer in spite of a number of hurdles and difficulties suggested during the argument. It is not disputed that the decision of Mr. Justice Shah does constitute a judgment within the meaning of clause 15 of the latest patent. That being so, his judgment was subject to appeal under that clause, the material part of which relevant to this inquiry is. And we do further ordain that an appeal shall lie to the said High Court of Judicature at Bombay from the judgment of one judge of the said High Court or one judge of any division court pursuant to section 108 of the Government of India Act. It was said that the provisions of this clause could not be attracted to an appeal preferred by the High Court under section 76 of the Trademarks Act, and further that the clause would have no application in a case where the judgment could not be said to have application in have been delivered pursuant to section 108 of Government of India's Act. Both these objections, in our opinion, are not well founded. Section 76(1) provides, save as otherwise provided in Act, an appeal shall lie within the period prescribed by the central government from any decision of the registrar under this Act or the rules made thereunder to the High Court having jurisdiction. The Trademarks Act does not provide for or lay down any procedure or the future conduct of or career of the appeal in the High Court. Indeed, section 77 of the Act provides that the High Court can, if it likes, make rules in the matter. Obviously, after the appeal had reached the High Court, it has to be determined according to the rules of practice and procedure of that court, and in accordance with the provisions of the charter under which that court is constituted and which confers on it power in respect to the method and manner of exercising that jurisdiction. The rule is well settled that when a statute directs that an appeal shall lie to a court already established, then that appeal must be regulated by the practice and procedure of that court. This rule was very succinctly stated by Viscount so-and-so in the terms, when a question is stated to be referred to an established court without more, it, in my opinion, imports that ordinary incidents of the procedure of that court are to attach, and also that any general right of appeal from its decision likewise attaches.
Not being clear করে দিয়েছে। Not being a judgment made in the exercise of appellate. Yes.
Lord, kindly see the last paragraph in this page 21. Says the same view was expressed by their lordship in Privy Council in such and such, wherein it was said, where a legal right is in dispute and the ordinary courts of the country are seized of such dispute, the courts are governed by the ordinary rules of procedure applicable thereto, and an appeal lies if authorized by such rules, notwithstanding that the legal right claimed arises under a special statute, which does not in terms confer a right of appeal. Again, in Secretary State of India versus such and such, when dealing with the case under Madras Forest Act, their lordships observed as follows. It was contended on behalf of the appellant that all further proceedings in courts in India or by way of appeal were incompetent, these being excluded by the terms of the statute just quoted. In their lordship's opinion, this objection is not well founded. Their view is that when proceedings of this character reach the district court, that court is appealed as one of the ordinary courts of the country with regard to those procedure orders and decrees the ordinary rules of civil procedure code apply. Though the facts of the case laying down the above rule were not exactly similar to the facts of the present case, the principle enunciated therein is one of the general application and has an opposite application to the facts and circumstances of the present case. Section 76 of the Trademarks Act confer a right of appeal to the High Court and says nothing more about it. That being so, the High Court being seized as such of the appellate jurisdiction conferred by Section 76, it has to exercise that jurisdiction in the same manner as it exercises its other appellate jurisdiction. And when such jurisdiction is exercised by a single judge, his judgment becomes subject to appeal under clause 15 of the latest patent. Then, Lord, 116 onwards, Lord, I thought, Lord, it is a very, very well considered judgment. It considers, Lord, all past judgments into consideration, and Lord, it also takes into consideration the judgment of the Supreme Court, which is quoted in extenso. And your lordships will find that it says it is on the Trademarks Act. And therefore, I thought, Lord, I would bring it to your lordship's notice that even if there is no appeal provided, it will go by the procedure prescribed by the court. And it is not, Lord, outside the jurisdiction of the court to prescribe its own procedure. And clause 15 cannot be a bar because of the reading of the section 100 capital A of the Code of Civil Procedure. If it is not an order or a decree from which the first appeal is entertained by the High Court, there is no question of excluding clause 15 of the latest petition. So, my lord, even in framing of the rules, the High Court, my lord, retains its jurisdiction, and it is within its power, my lord, to frame rules for the purpose of preferring of an appeal. And my lord, there is a provision for an appeal, and we are before your lordships. And I showed, my lord, that both Bombay and the Delhi High Courts, Lord, they are exercising their appellate jurisdiction. Why shouldn't this court do the same exercise? Lord, these are my humble submissions. And I just say in one word, none of these judgments are blood applicable in the facts of our case. One was the Company Law Board. Company Law Board was constituted by giving up, Lord, a jurisdiction of the High Court. Therefore, Lord, it had, Lord, not only it had a trapping, but it was actually, Lord, considered to be a civil court. And therefore, the appeal was allowed under 10F. So, Lord, the question of this 100A being read into such a situation was absolutely apt. And the other judgments also, Lord, follows the same principle, where, Lord, the civil court's order is in subject matter in an issue. Lord,
No reply. Only on the
We are not touching merits at all.
Only on the point of jurisdiction. बोले ना चलो तुम.
2 points. First, my lord, resilient. Latest judgment, the last judgment by Mr. Court. This is on a rectification which is akin to 93. 93, any order is appellable. This order is not under 91 but 93. So this is a perfect judgment on 93. Number one. Number two, my lord. If my lord have the latest Copyright Act, Section 72 deals with appeal, where subclause 3 says there is a provision of second appeal, which is not there, which is after the Tribunals Act, which is not there in Copyright Act, the Trademark Act. I just bring up. But the Section 72 says any person that appeal aggrieved by the final decision order of the Registrar of Copyright may be 3 months the date of order decision of appeal to the High Court. Then 3 says where an appeal is heard by a single judge, a further appeal shall lie to a bench of the High Court within 3 months. So this is after the Tribunals Reform Act. So a second appeal has been contemplated under the Trademarks Act under Section 72, which is not
Copyright Act.
Copyright Act.
Trademark Act.
You confuse us. As it is, we are confused.
Sorry. Under the Copyright Act, which is not there in the Trademarks Act. So we have to subsection O of Rule 4 of Proceedings. They just said that any other proceeding.
That cannot confer a right of appeal. Where appeal lies.
So when Copyright Act has specifically said an appeal is maintainable. Therefore, my lord.
Very well, we have noted it.
And then, my lord, the third point is, my lord, while considering the first judgment of Justice Verma, which is 2023, the main thrust is on 77, that the order is not an order contemplated under Section 2 of the Civil Procedures. That is the only thrust which has been given, since it is not an order under Section 2, 100 apply. Doesn't apply. But my lord, anyway, it's an appeal, a second appeal, and a second appeal can be only on points of law, which has not been there in any code of court. So therefore, this judgment is also not applicable, my lord. These are my respectful submissions.
Mr. Ghosh.
Millard, Copyright Act point, Millard, she has already taken. So
Yes.
no point, Millard,
No.
going again and again. Now, Millard, Delhi High Court's judgment, if your lordship takes, first of all, that trademark point, the IPAB transfer point doesn't apply here. Because this is a proceedings which is filed directly to the High Court after the enactment of the Tribunal Reforms Act. Millard, my appeal, the appeal which is preferred by me, is appeal under section is titled Appeal under Section 91 of the Trademarks Act 1999 from an original order of the registrar. So in effect, Millard, the IPAB division's honorable single judge is performing an appellate function. As my learned friend on the other side rightly said, if it is there in the copy, like the Copyright Act, of course it's maintainable. That is, my lord, my lord, rules are, my lord, subservient to the statute. Now, my lord, with that, my lord, you cannot get an additional forum for appeal.
Yes.
And in effect, my lord, the full bench of Delhi High Court, my lord, Awadh, my lord, that is quoted, it has been subsequently followed, and this is not followed. If Lordship wants, I can hand up, my lord, that is followed. The full bench decision, my lord, is followed, and this is
Followed
by a division bench.
of
The
Delhi
full-
High Court.
Delhi High Court. Delhi High Court is following, my lord.
Give
The
it,
fu-
give it, give it.
I will give that. Promo sheet is not followed. What is followed is, my lord, দাও চট করে দাও ঢুকিয়ে ফেললে কেন? But they-
I get this at the first instance. None of these judgments, this judgment he is citing in reply.
No, I'm not. It's not. I'm not. Awadh, my lord, there's a full bench. There's a full
Awadh
bench.
has been considered.
Yes,
Awadh is
considered, my lord, considered wrongly. My lord, that's the thing, my lord. Deepest of respect.
Issue.
Appeal doesn't lie. There is no provision for any appeal.
এক নম্বরে যে অর্ডারটা we have heard এক নম্বর item.
No,
Learned senior counsel for the parties at length on the point of maintainability of the appeal and not on merits. Stop. On this point, comma, we reserve our judgment. Stop. The matter will be listed for judgment on the point of maintainability. We are not giving a date.
No.
As soon as possible. 2 থেকে 8 বুঝে নাও, শোনো, 2 থেকে 8 নিয়েছেন একজন, কন্ডোনেশন অ্যাপ্লিকেশন গুলো অ্যালাউড হয়েছে, হয়ে তারপর একটা অ্যাড করবে. Shall we also pass the same order that we have heard on maintainability?
Yes,
In-
all matters.
All the matters can be heard on.
দেখি,
Lordship wants a
হ্যাঁ, তাই করো.
Or your lordship can give judgment in number one and Lord, the others will follow.
that is what he was agreed, my lord, before the trial court on the lighter side. Can we file a one-page note? If so, this is not necessary. Other matters,
What?
I normally ask about that. Wait.
Number 9.
এটাতে বুঝলে ভাই ভাই
Lordship, I am further responding in this matter led by Mr. Demarlo Ghoshal and Mrs. Aparita Ghosh. Lordship, I am praying for not today because we are lacking any material instruction today.
you are lacking in material instructions.
No instruction.
You have no instructions at all.
No, my
A
lordship.
very happy position. Yes, Mr. Mukherjee.
My lord, I am preferring an appeal from an order by which, my lord, my application for disclosure of certain additional documents, my lord, was rejected. My lord, there is also delay, my lord. In the petition, it has been incorrectly mentioned that the delay is 136 days. It ought to be 163 days, my lord.
Doesn't matter. You know our views.
My lord.
Have you? Yeah, they have been served, obviously.
Yes, my lord.
So when will you get instruction?
I think from by the end of this week, I lordship.
My lord, the respondent, my lord, will seize a bank, my lord.
Yes, my
The
lord.
suit is proceeding ex parte against the bank. In that premises, my lord, we had taken out this application which was rejected, my lord. This being a commercial suit.
Suit is proceeding ex parte against the bank.
Yes, my lord.
You are for the plaintiff.
I am for the
Lordship, we have
plaintiff, my lord.
appeared in.
They did not file the written statement within the prescribed period, my lord.
He is asking
we
for
have
some
appealed.
time.
I'm not objecting. I leave it to my lord.
Very well. Will let us dispose of the section 5?
My lords.
GA now, GA1 or GA2? Which
My
one?
lord, GA1 is, my lord, the application for condonation of delay.
GA1 to now. This is an application for condonation of delay of 163 days as noted by the stamp reporter. দেখি stamp reporter report করেছে কিছু? Note করেছে? কোথায়? 136 days করো। In presenting this appeal, top causes shown being sufficient, the delay is condoned. Paragraph GA1 is disposed of. তারপরে appealটা GA2টা নিয়ে লেখো। Learned advocate for the respondent bank seeks time to obtain instructions. Paragraph list this matter once again next Monday.
My lord, may I take this opportunity to seek leave from my lord to my lord put in the plaint, my lord. The plaint has not been annexed. May I seek leave to file a supplementary affidavit?
Paragraph leave is granted to the appellant to file supplementary affidavit to bring on record certain relevant documents which have been inadvertently not annexed to the stay petition as submitted by learned counsel for the appellant. Appellant করবে। চলো সোমবার appeal as GA2, GA1 টা disposed of.
Come back next month. I'm grateful.
Specially assignment as item number 10.
I was addressing Mulot.
You will keep us engaged for this half?
Yes.
Release করে দাও এই halfটা।
All the matters are released, clearly says, except this matter.
Volume কতটা? Lord, we were at the very interesting paragraph, Mulot, paragraph 1065, 106, where Mulot, the logic of Mulot, the MGO clause Mulot was given. Remember Mulot, Bihar State Electricity Mulot, which quoted Mulot a Calcutta High Court judgment.
Yes.
This is Mulot, page 4742, volume 6 বোধহয় যাচ্ছে। And volume 4742. Compilation থেকে বোধহয় দেখছিলাম। বোধহয় যচ্ছটা কম্পিলেশন থেকে দেখছেন। Page 53 বোধহয়।
Page 53 of the compilation.
Compilation volume. Compilation না সরি কম্পিলেশন থেকে দেখছেন বলে দিচ্ছে না, ওখানে একটা এডিশনাল ওই অ্যাওয়ার্ডটা আলাদা ছিল
এরকম একটা কম্পাইলেশন।
হয়তো হ্যাঁ ওটা সরি আগে কম্পিলেশনটা দিয়ে আরেকটা বলো
Page
53 मतलब पेज 53 বা আগের পেজ 52 থেকে
internal page 53.
internal page मतलब
Internal page 34.
internal page 34
Running
मतलब can we
Yes, on the rationale of MGO clause.
yes this is मतलब where we stopped मतलब why I am bringing it up मतलब it's very interesting मतलब ask me a question मतलब it was 63 Calcutta मतलब which is quoted मतलब find मतलब in 106 at page 35 6 AIR 63 Calcutta 265 Can you just look at this one? Supreme Court, while explaining the rationale of minimum guarantee charge in Bihar State Electricity Board, relied on a judgment of Calcutta High Court case of Mrs. Sholobala Ray versus Chairman Darjeeling Municipality. Learned counsel for the claimant relied strongly on those formulations by Calcutta High Court, which were approved by the Supreme Court. They are set out here and below. Then, my lord, it was really based on the principle that every consumer's installation involved the licensee in certain amount of capital expenditure, plant and mains, on which he was to have a reasonable return. He could get a return when the energy was actually consumed in the shape of payments of energy consumed. When no such energy was consumed by the consumer, or a very small amount was consumed in a longer period, the licensee was allowed to charge minimum charges by his licensee, but those minimum charges were really interest on his capital outlay incurred for the particular consumer. It had fallen from whether Justice P.B. Mukherjee. And I thought Justice P.B. Mukherjee was before 63. That's not correct. Justice P.B. Mukherjee was in 1963. Not Justice P.B. Mukherjee judgment, but he is 1963. And I found Justice P.B. Mukherjee and Justice Bachawat both were on the bench at the same time. This is actually not 63. It is AIR 1936 Calcutta.
This one?
Yes. It's a misprint, that's 63. It's AIR 1936 Calcutta 265. And our little research makes it very interesting. This is by Justice R.C. Mitter.
Ramesh Chandra Mitter.
Rupendra Kumar Mitter.
Oh.
And again, very interesting. This Rupendra Kumar Mitter appointed in about 34. He was the acting Chief Justice. He was knighted in 46. He was the acting Chief Justice of Calcutta High Court when India got independence.
Oh.
He became Sir Rupendra Kumar, obviously. Kumar, he writes CWMAR.
So as on 15th August 1947, he was the acting
Chief Justice of the Calcutta High Court. And further interesting, and he was MSc Maths and then Law. Further interesting, his son was Shomanendra Kumar, again Kumar Mitro.
Not Mitter.
Not Mitter, Mitro. He is considered to be the founding father of Indian computers. And if looks at his educational qualification, I and Mr. Mukherjee were discussing Harvard, Oxford, Harvard, Cambridge, Princeton, and he was part of ISI when he set up the first analog computer of India. This is the kind of excellence we had.
Absolutely.
In 1950s. So very interesting, because I started looking, because it was quite precise. I also like the language which was there. And since it fell from my Lord Justice Mukherjee, P.B. Mukherjee. So I went back looking, and then I couldn't find that judgment at all. Then with the name I found that's 36 Calcutta. In fact, we have the copy of the judgment.
He had nothing to do with the Elgin Road meters.
No. In fact, I also called.
I see.
My lord can read my thoughts, my lord. I called, and interestingly, he gave me the first name also. I said, "How do you know?" No, I keep track of.
Okay.
Because I also didn't know what the first name was. When actually, Ramesh Chandra is much before.
Yes.
So that's 1800s, my lord.
Yes.
And my lord, so was I think PC Mitter, my lord, also was the before 20 must have been 20s.
Very well.
Here, my lord, can you just look at the last page where my lord that is there at page 1051. But since we were at this judgment, I'll also show the other MGO judgment clauses, because I think we have slightly want to deal with the arguments made by the other side. Can you see in the middle a minimum charge? That's the quotation.
Yes.
So here what had happened, very interesting. It came from Darjeeling. The agreement did not have this clause for minimum charge. They introduced it by statute. Dealing with that, Justice Mitter said, no, it has to be in the contract. You can't impose it by statute, but it has to be in the contract. And that's where the rationale of this clauses I explained. And says minimum charge is not really a charge, which I've just read out, that's quoted there.
Counsel for the opposite party was Sharat Chandra Bosak, Justice Bosak's father, Bimal Bosak.
Bimal Bosak. Oh, that I also know. The similar. I've not. I've not seen. Malad would have much before, I think.
Justice Bimal Bosak. No, I knew him from childhood in other capacity.
Not
on the bench. No. When I joined the profession, he was the Chief Justice of Patna High Court.
Oh.
Already gone from here.
Oh, that I wasn't. I know he was the Chief Justice, but I thought it was much before when Malad had. Now, Malad, one Malad submission, I think Malad, with Malad great respect and Malad with really Malad utmost humility. Malad, I think Malad, my learned friend Malad, Mr. Mitro, his argument on the question of damages, and I'll also show that Malad factually, is with great respect I submit Malad, perhaps is not the right principle. Because today, the breach of a contract, the principle for grant of damages is that you have to be put into the same position as if the contract had been performed. Here, the performance of the contract would have been that I would have got my minimum guaranteed charges till the end of the contract. Theoretically, that's what is correct. And that's section 73 as well, as if the contract had been performed. Now, this submission, relying on the CRISIL report or the CARE report, is not good enough to show that I would not have earned from the contract. And why I say so, Malad, it's not a question of Malad suffering damages. It's not a question of incurring damages, suffering damages. My learned friend to deprive me of damages would have to show that I had no available gas with me. Absolutely no available gas. It has to be a finite quantity which is exhausted because there was a demand for that. Finite quantity, because that's nowhere in evidence. That's why I say perhaps we were really with great respect, again I submit perhaps we are looking at the wrong principle. And that example, which I gave with the cars was very important. I have a finite number of cars. I have 100 cars to sell. You are supposed to buy 20. You fail. I sell the 20 to someone else. I only have 100, therefore no. But if I can manufacture and sell, then quite naturally I would have had that additional 20. So you have caused me damages. I have failed to earn profit on the quantity which I could have sold to you. So perhaps this is the logic which I greatly submit this, because this point was really not, like I said, not so strongly argued, at least in the first court. So that perhaps it is wrong principle, unless you are able to show there was no gas available at all. then only the question comes of depriving me of any profit. Because if the contract had been performed, if I had not wrongfully terminated, if the contract had been performed, then I would have got, if you did not consume, I would have got my minimum guaranteed charges. If you did consume gas, it would have been more than that. So this is where in fact we'll find when I show that Bihar state electricity which was followed by another Orissa I think also dealing with electricity, where the Honorable Supreme Court upheld those clauses for the purpose of recovering money, even when the connection was the supply was disconnected by reason of non-payment. Because quite naturally, you cannot defeat the purpose of the contract by not paying. And then quite naturally, I will disconnect. But then you can't come and say, oh, disconnect, I will not give you any money. And in both those cases, that clause was upheld. And that is the logic. Because today, in the award, if I may say so, there are 3 or 4 things which are very important. First, on the question of the MGO clause waiver. It's a factual finding that there will be no waiver of the clause. Second, on evidence, court finds, or rather the arbitrators find, that if MGO clause was not waived, then your termination was wrongful. Because admittedly, you failed to renew the security which was supposed to be renewed. And thirdly, on the question of evidence, court says if you have breached, then this is how we are calculating the quantum of damages. Now, unless that is shown to be absolutely impossible or an implausible, it's not plausible at all, then only the question of interference comes in into this. So, by my learned friend showing, and that's what I said, and which I want to make good also. In the argument, what they said, in the notes of argument, which what they said, how they relied on CARE and CRISIL. And I will also show the reports. In fact, CARE and CRISIL, particularly I think CARE, it goes in my favor. Because it also records, I have commitment. 20 years commitment from so many people, from my customers. And that is how it is planned. I have to go on paying my royalty for the gas, irrespective of whether I take it, not take it.
No, the grievance that Mr. Mitra was making regarding those reports is not anything to do with the merits. That the reports were not even adverted to, considered at all. This is what.
With great respect, first I'll show it's been adverted to, and secondly, it is not every evidence not considered will make a difference. It has to be material evidence,
Of course.
which would have changed the course of the arbitration. Otherwise, obviously, there will be
No,
several.
which would have bearing,
Correct,
material
correct,
bearing.
correct.
Yes, on the
Absolutely.
decision.
Absolutely. Just by coming and saying, if I came and said, oh, I gave 20 documents, only 2 were considered. 18 may be irrelevant. Arbitrators may not have adverted to it because it doesn't change. Only if it is, that's why I said, perhaps it won't make a difference, because unless they're able to show that the CARE and CRISIL report said that there was no gas available. In fact, it says to the contrary. Because these reports are prepared because this company which is now the respondent and the claimant there, they're preparing for IPO. So you'll have to get reports for the IPO to file it with the stock exchanges. 2 reports 2014, the CARE also was with regard to in 2015 as well. So that is what the situation. Now coming back, I'm so sorry, just coming back to that the award itself. হ্যাঁ ওটা তো 106 will be our electricity board 106 ও তাই then my lord internal page to 53 my lord internal page number 36 of the award paragraph 107. The learned counsel for the claimant also relied on decision case of Universal Resources Corporation versus Panhandle Eastern Pipeline, particularly head note 5. This was an American case we relied upon to point out the purpose of take or pay clauses. In the said head note, the court explained the purpose of take or pay clause in the following manner, which is set out. Purpose of the take or pay clause is to apportion the risk of natural gas production and sales between the buyer and the seller. Seller bears the risk of production. To compensate seller for the risk, buyer agrees to take or pay, and if not taken a minimum quantity of gas, the buyer bears the risk of market demand. The take or pay clause ensures that if the demand for gas goes down, seller will still receive the price for the contract quantity delivered each year. Then head note 6 of the judgment, court further point out terms of take or pay. Then kindly see 109, where we relied on commercial court judgment of in Europe ছিল হ্যাঁ এই ছিল ইউরোপ ছিল then kindly come to
This is which court? This
I think it was we did a lot of research at that time to try and support this. In fact, I think it's also referred we showed a Lahore High Court এটা কোথায় EWH টা বলো I have we have a it's Queen's Bench Division Commercial Court.
Oh.
It's also report Allington report. I think EWHC was given. এটা দুটো হয়ে গেছে since we are also reading this may I also hand up this was I'm sorry it bears I'm so sorry the cost title of the petition the section 34 petition kindly excuse us for that but this is the that is the compilation যেটা দিয়েছে হ্যাঁ soft copy airdrop anyone just wants to have a look at it we can quickly refer to it and then I don't have to place it separately we'll find this is what we relied on first courts may assess loss of future profits due to wrongful termination 5 cases then on the sufficiency of evidence that Sangyong be relied upon and Atlanta Limited. Then validity and enforceability of MGO clauses. This is where we are.
yes.
And page 218 is the Lahore High Court. Came from an award. my lord, coming back, my lord, to the award, my lord. Paragraph 108 I've shown, 109, my lord, is the next. That's, my lord, I showed that 109, then, my lord, 111. Reliance was placed on paragraph 28 of the decision case of Port of Tilbury, Stora Enso Transport Distribution Limited. Then learned counsel claimed the purpose of arguing that nothing absurd about the take or pay clause. In the decision, court made it clear, paragraph 28, therefore, that such provisions are common and particularly used when one party has to spend significant sums of money for the purposes of the contract and needs to look to the contract for the secured annual income stream, which will pay the ongoing financial cost of his investment. Then, my lord, 112 is, my lord, American case, my lord, which we relied upon. Then, my lord, 113, my lord, will find, my lord, the Lahore High Court on the rather elaborate judgment of Lahore High Court in Orient Power Company Limited is incited. Then, kindly come to page 116, my lord, on the question of, my lord, the no damages suffered, my lord, that argument is there. What? Then, my lord, kindly take page, paragraph, my lord, 116. Just before, my lord, paragraph 117. Keep page. It is clear from the aforesaid discussion. Page 58, my lord. It is clear. Thank you. From the aforesaid discussion that questions involved in those two cases was whether supply of various item members should amount of sale. Question is not even. Then 117. It is difficult for this tribunal to accept the aforesaid argument of the learned counsel for the respondent about the MGO clause in GSPA for the reason discussed hereunder. This is, my lord, very important. 117. Challenging the validity of this very MGO clause in the present GSPA, proceedings were initiated by the respondent before CCI. And its appellate authority, and also before the High Court of Delhi. Those proceedings were initiated virtually on the same grounds on which MGO clauses are sought to be assailed by the respondent in the SOD filed before this tribunal. In all this fora, it has been held that MGO clause is valid on almost similar grounds, which found favor with the Honorable Supreme Court in the case of Bihar State Regulatory Board, and which was followed by the Supreme Court in the case of Orissa State Regulatory Board. In both these cases, Supreme Court held that liability of the consumer to pay minimum guaranteed charges continues even after the connection was disconnected by the Electricity Board. The reason for upholding MGO clause in the judgments delivered in various foreign courts are also on identical lines. Even if the tribunal is not bound by the judgment delivered in foreign courts, but they have a persuasive value. Goes without saying that this tribunal is bound by the concurrent decision CCI and its appellate authority and the Delhi High Court, obviously the Supreme Court. As such, the validity of the MGO clause in the present GSPA is no longer open to be impeached by the respondent. Respondent counsel also accepted the findings reached by, this is very important, Lord. Respondent counsel has also accepted that the findings reached by CCI and Delhi High Court are binding on this tribunal. The learned counsel for the respondents could not effectively distinguish the two Supreme Court judgments referred to above and the applicability of the ratio to the MGO clause in the present case. The learned counsel for the claimant referred to the decisions on MGO clause and various other jurisdictions discussed above in order only to show that the take or pay clause considered in this judgment, which is almost similar to the MGO clause here, is a common feature globally in commercial agreement relating to supply of gas or electricity. As this commodity is to be supplied cannot be stored, but if not taken, they have to be flared up. And to set up a plant for supply of such commodity, substantial investment is required. Therefore, MGO clause is a part of the price mechanism of the items to be supplied. That explains why MGO clause has been upheld globally and in every jurisdiction. This is clear from the failed negotiations of the parties in this case. Also, when the respondent wanted the claimant to waive the MGO clause, claimant wanted to hike the gas price. It is thus clear MGO clause is connected with price mechanism. some difference between the take or pay clause in the judgments in the foreign courts and MGO clause GPS cannot make the MGO clause present GSPA vulnerable when its validity has been affirmed repeatedly as CCI and Delhi High Court for reasons which found favored the Honorable Court, case of Bihar State Court. Then in Delhi High Court judgment dated 10/10, wherein present MGO clause was also challenged, High Court noted in paragraph 36, admittedly GSP embodied an agreement which was negotiated between the said parties. Neither of them had complained against the same to CCI. Again, paragraph 38, High Court found parties had entered into a protracted negotiation for closing the GSPA would certainly be a relevant factor in considering whether GCL had imposed unfair terms and conditions. 39, High Court found that CCI had noted parties had exchanged drafts of the GSPA before finalizing them. Court also noted in paragraph 61, High Court noted that in 11th May 2011, when the GSPA entered, no grievance has been raised by SRMPA regarding GSPA. Considering all these facts, High Court dismissed the writ petition instance of SMBA as unmerited and abuse of the process of law. This conclusion Delhi High Court binding on this Honorable Tribunal. These were inter-party finding which were there. This is the same matter which was initiated by. This tribunal finds that such MGO clause is quite common in gas purchase agreement. Every jurisdiction clause has not been found to be not a provision of terrorism. Tribunal, therefore, for the reasons discussed above, holds the present MGO clause in GSPA negotiated between the parties and agreed upon respondent invoices raised thereunder paid by the respondent valid. Tribunal subsequently deal with the consequent non-fulfillment of MGO clause as a result of determination of the GSPA. So this finding is very clear, also based on Delhi High Court both CCI and Delhi High Court judgment. Seeing the GS. So now the consequences have to follow. If the clause is valid, there would have been effect of that clause if the contract had been performed. Now next, some other developments which I'll just very briefly go through it. This is with regard to the SR also, I think SRR plus bank guarantee renew. Paragraph 119. That's on page 60. No, 61. Before termination of GSP by the respondent, certain other developments took place and brought to the notice of the tribunal. Claimant's case is as the respondent was not renewing the bank guarantee of 93 lakhs, which was expiring on 31st May, despite the request claimant to the effect by its letter date 18th April. Claimant further case is that in the meantime, this is more important, the claimant's further case is that in the meantime, an agreement was entered into by the respondent with SR Oil and Gas Exploration and Production Limited for purchase of CBM gas. This is admitted by Mr. Beriwala, RW4, the main witness of the respondent, that the date of agreement with SR is 25th April and supply of gas from SR started from 25th April. Answer to 86 and 87. Fact of the respondent's agreement with SR about supply of CBM was not mentioned by the respondent's notice of termination dated 7 July 2014. Claimant wrote another letter on 30th May to the branch manager Oriental Bank of Commerce that the aforesaid bank guarantee is expiring on 31st May and the renewed bank guarantee was not received by the claimant. As such, the claimant requested bank manager to create a lien against the subject bank guarantee. As the respondent was asking the claimant to return the original bank guarantee by its letter dated 29 May 2014, the claimant's reply by letter dated 31st May asked the respondent to renew the bank guarantee adhered to GSP and reiterated MGO clause cannot be waived. By another letter also dated 31st May, claimant reiterated that GSPA is valid till 30th April 2034 and its termination earlier is subject to damage. On 2nd and 4th June, claimant further informed the respondent that its proposal for novation of the terms of GSPA not acceptable. Claimant that the consumption of CBM gas by the respondent is nil since 31st May, though gas is allocated to it on daily basis. Gas, if not consumed, is to be flared up. As noted, by end of April, respondent entered an agreement with SR for supply of CBM gas. Sometime in the second week of June, the respondent filed a civil suit in the High Court, and in that civil suit, an order dated 12 June was passed by the Honorable Justice Mukherjee, wherein learned judge noted that one bank guarantee is expired, the other bank guarantee has not been invoked. Learned judge directed status could be maintained till 28 June. Suit was filed by respondents. Claimant was invoking the bank guarantee. In the meantime, claimant on 1st July 2014 raised bill for supply of gas and MGO to the extent of 1 crore 35 lakhs. Therefore, after in the said suit, another order was passed by the learned judge and contested hearing on 1st July. And in the order, learned judge directed the respondent immediately renew the subject bank guarantee, meaning thereby subsisting bank guarantee. Learned judge noted in the order that one bank guarantee expired, dispute over the other bank guarantee. Court directed respondent to renew the existing bank guarantee suitably by 10 July up to 31st December upon notice as the claimant. Also directed existing supply of gas to the can only be discontinued claimant given 3 months notice answer. Claimant's case, respondent suddenly started consuming gas on from June 23rd in high volume in a short span of time, resulting in disruption gas supply and reduction in volume as the respondent started consuming gas beyond contracted MGO quantity. Claimant annexed a chart at page 107 to show the nature of gas consumption, shows no consumption from 1st June to 22nd June. Respondent dealt with his assertion. Claimant in sunset did not delay the chart at W. Because what they did, my lord, that was a case, and my lord, which has been considered, because that subsisting bank guarantee was there. So, my lord, they consumed gas so that, my lord, the amount of the bank guarantee, my lord, was exhausted. And then, my lord, they terminated, my lord, on 7th of July. And the order records that, my lord, give me some time. You must ask them to continue till 15 because I have to look for another gas supplier. So that's why, my lord, the courts, my lord,
Smart, very smart.
all this, my lord, happens, my lord. So then, my lord, paragraph 129 records this. Claimant's case is that the respondent started consuming gas in excess quantity, being aware that the bank guarantee which is lying furnished by the respondent does not cover the amount towards the contracted quantity for 1 month, terms of clause 11.5 of the agreement. However, means paragraph 20 has not been denied by the respondent. Paragraph 10. Claimant's case, the respondent was consuming gas without providing sufficient security as present GSP, and the consumption exceeded the contract quantity up to June 23rd. 131. Claimant's further case is that by reason of higher consumption of gas by the respondent in short period, within shorter period than 24 hours, natural forces affected the pressure of supply and supply became erratic. As such, claimant gave a notice 2nd July, requested to renew the bank guarantee of rupees 93 lakhs and also gave 3 days notice for suspension of gas supplies. According to claimant, respondent was consuming gas without giving security. Claimant wanted respondent to read this notice of suspension. Respondent sent 2 letters dated 3rd July and 4th July alleging disconnection of gas supply by claimant. Letter dated 3rd July, respondent alleged the claimant is acting in contempt of the order of the Honorable Court dated 1st July and pending suit, and called upon the claimant to immediately restore supply of gas or will take appropriate proceeding. Then 133. On 4th July, respondent again rated a grievance. Then 134, 4th July, this went on. Then, my lord, on 137 is on 7th July. So, my lord, the excuse they got on 7th July 2014. The respondent issued a letter at 7th July 2014 for termination of the GSP agreement at 11th May. In the said letter, respondent alleged that the claimant systematically suspended gas supply to the respondent's factory since 2nd July and permanently suspended gas from supply from 5 AM of 6 July 2014. Respondent alleged that the suspension was legal, breach of GSPA. Respondent further alleged that the claimant demanded renewal of bank guarantee, which according to respondent expired on 31st May. By mutual consent, alleged that disconnection of supply is malefic, arbitrary, and violation of High Court's order.
Mr. Banerjee, will you continue after recess?
Yes, Lord. I'm sorry, Mother. Yes. Continue.
Continuing matter, I will not take.
Maybe continue, my lord, since both sides are here.
Yes.
So there is a
There's a resolution.
there's a resolution.
There's a resolution.
Yes, from
No,
2 p.m.
Why? For whom?
Oh, Mr. Dastu.
Mr. Dastu. We haven't been informed.
No, but anyway, my lord, it's in the absence. That's what, my lord, I'm told there is.
The rider is in the absence of any party.
But in a situation, if you have the next matter, then it's a big problem. If the people want to 3:30 and then 3:30 also is fixed.
3:30 fixed, yes.
Fixed matter again before lunch. Should I just Mr. Joint to argue? KT argue. Well, page 67,
Yes.
paragraph 137.
Yes.
Well, paragraph 137. On 7 July 2014, the respondent issued letter dated 7 July 2014 for termination of the GSP agreement dated 11th May 2011. 2014, sorry. In the said letter, respondent alleged that the claimant systematically suspended gas supply to the respondent's factory since 2nd July, permanently suspended supply. The respondent alleged that the said suspension was illegal, breach of GSPA. Respondent further alleged their case which they made out in the termination. Respondent further alleged the claimant demanded renewal of bank guarantee of rupees 93 lakh, which according to the respondent expired on 31st May. By mutual consent, respondent alleged that disconnection of supply by claimant is malafide and arbitrary in violation of the High Court order dated 1st July. For the above reason, respondent on 7 July 2014 issued notice of termination of GSPA with effect from the interesting on 15 July 2014 and requested the claimant to invoke the subsisting bank guarantee for the bill dated 1st July for rupees 63 lakhs. Respondent further alleged that MGO claim is not valid and is the subject matter of pending suit. Claimant was also requested to raise further gas supply bill for the period from 1st July till 15 July, which is the effective date of termination of GSPA, and to invoke the subsisting bank guarantee. Why I said, my lord, subsisting bank guarantee for the billed amount for that period and thereafter return the original bank guarantee. Respondent claimant was further requested to restore further supply of gas to the respondent till 15 July to enable them to make alternate arrangement. Then, my lord, 139, we can, my lord, just skip over, then kindly come to 140. On 8 July 2014, Honorable High Court, in the pending suit, passed an order on a contested hearing whereby the High Court allowed the claimant to encash the subsisting bank guarantee of rupees 1.75 crores. In that order, High Court noted that pursuant to leave granted by the High Court's order dated 1st July, claimant by giving 3 working days notice disconnected the gas supply. However, on the submission of learned senior counsel of the claimant, High Court recorded that the claimant can resume supply provided the respondent pays for it and provides the security required for such supply. On that basis, the court ordered that the respondent will be entitled to supply of gas up to 15 July 2014. And the claimant will be entitled to encash the bank guarantee of rupees 1.75 crores immediately, wherefrom the claimant will adjust the price and charges for gas supply. And such supply will continue uninterrupted up to 15 July 2014. Court also observed dispute between the parties may be resolved in properly constituted pendings between themselves. Then kindly similar. Thereafter, the High Court in the morning of 11 July 2014 passed an order directing the respondent to make payment for a further sum of 50 lakhs on account of supply of gas by the claimant on and from 1st July. Case of the claimant is after such prayer was made by it, respondent's counsel agreed to furnish a bank guarantee of 50 lakhs in favor of Registrar, High Court, original side. Thereafter, matter was again mentioned at 4 p.m. on that day by advocate representing the respondent, seeking to withdraw the offer, which was made in the morning on the ground that proper instruction not received by the advocate. Prayer was made that the claimant can be directed to forthwith discontinue supply of gas of respondent will not be able to furnish the bank guarantee rupees 50 lakhs. Then, Mulad 142, they filed a contempt against us, Mulad, saying we are in violation of the order of 1st July and 8th July. Then, Mulad 143, the contempt petition was disposed of with the finding that the order agent did not make any final adjudication, and Mulad court observed that we have not violated any order. Then, Mulad 144, arbitration started. 145, civil suit appeared. Then, kindly see, Mulad at 146 onwards. This is very important. Whether termination of GSPA by the respondent is valid. The contractual provision for termination in GSPA are contained in two of its clauses. First is contained in clause 5.1, which is, well, I'd shown all these clauses. I'm not repeating this clauses. Then kindly come to 147. Perusal of this clause shows that gives right of termination both the parties on certain terms. Then 148, clause 15 is noticed. Then 149. In the instant case, seller, which is me, has not terminated the contract. The buyer, the respondent herein has terminated the contract, and in paragraph 54 of the SOT, it gives reasons for such termination. Claimant disputed all contentions raised by the respondent, and this tribunal has to decide whether termination of this contract by the respondent is right or wrong. From the contractual provisions, it is 151. It is clear that the respondent, the buyer herein, can terminate the contract only where there is reduction in supply or stoppage in gas supply for the seller for a continuous period of more than 3 months. Admittedly, same is not the case, as would be clear from a perusal of paragraph 54 of SOD and notice of termination dated 7 July. The only ground in support of termination stands in the notice is suspension of gas supply since 2nd July 2014 and followed by permanent suspension of supply from 5 a.m. of 6 July. In the said notice, it has been denied that the respondent has not renewed the bank guarantee of 93 lakhs. In the notice of termination, respondent did not allege contract between the parties was repudiated by the claimant. Then will kindly come to 152 is our case that they were bound to renew the guarantee of 93 lakhs. Then 153 discusses one of the two guarantees. Then kindly come to paragraph 155. This is the case which was argued before the first court. Respondent's case is that the bank guarantee of rupees 93 lakh is not required to be renewed as MGO clause has been waived. But this tribunal has already held for the reasons indicated herein before that MGO clause was never waived by the claimant. That finding I had shown earlier. It also appears from the letter dated 31st May referred to above that it wanted the respondents to adhere to the terms of GSPA, which is valid till 30th April 2034. And in case the respondent tries to terminate the agreement, it will be liable to pay MGO for the remaining period under terms of GSPA. To that, the respondent replied by its letter dated 2nd June, contending that it would consume CBM gas at ₹26 on non-MGO basis, but the claimant consistent stand is there has been no amendment of GSPA and MGO clause was never waived. This tribunal has also held that there has been no amendment. The 156. The claimant is therefore right in contending that under clause 11.5 of GSPA, respondent was required to pay the shortfall in the security amount immediately on demand, and refusal on the part of the respondent to renew the security deposit is a breach of GSPA. And the claimant can suspend gas supply due to non-payment of dues under the contract. This tribunal is of the view that payment of dues under the contract wider than dues from non-payment of gas bills. Then if we analyze clause 11.5, that is analyzed, my lord, and then kindly see 157. In any event, suspension of gas supply for a period of 3 days or even for a period of a few more days does not entitle the buyer under the contractual provision to terminate the contract as has been done by the buyer by its notice dated 7 July. In the argument before this tribunal, Mr. Sansar, learned urged that even though the respondent has no right of termination of GSPA under its contractual provision, respondent terminated the GSPA. This was their argument in view of the repudiatory breaches committed by the claimant of the provisions of GSPA. Then Mulad 39 is placed. Then kindly see Mulad 160. Para 160 Mulad. This is at page 76, I think. Mulad. Yes. If notice dated 2nd July 2014 sent by the claimant without prejudice is analyzed, it will appear that the claimant has urged that as per GSPA, respondent furnished 2 bank guarantees, of which bank guarantee of rupees 93 lakhs furnished by the respondent was not renewed till the date of the said notice of suspension, despite requests made by the claimant to renew the same by several letters. As such, the claimant urged that the same is the default of the terms of GSPA, and respondent was consuming gas without giving sufficient security to the claimant as specified in the agreement. On that premises, claimant requested respondent to renew the bank guarantee within 2 days from the date of receipt of the letter, whereas otherwise claimant will be constrained to suspend gas supply, and for which 3 days advance notice was given in terms of the High Court's order to 1st July. Also stated that during suspension, respondent continued to remain liable for liable. Then 161. Then came the notice of termination of GSPA dated 7 July, in which the respondent contended that such suspension is illegal in breach of the terms of GSPA. Respondent further urged that the aforesaid bank guarantee expired on 31st May by mutual consent. Respondent has also urged that MGO clause in GSPA was also waived by mutual consent. As such, the respondent was shocked by the notice dated 2nd July 2014 of the claimant. Under those circumstances, respondent terminated the GSPA with effect from 15 July 2014. Respondent disputed the MGO bills raised by the claimant, but the respondent also requested the claimant to continue gas supply bill for the period from 1st July till 15 July, which is the effective date of termination, and invoke the subsisting bank guarantee for the billed amount for the said period. Now, kindly note this one. Next line. The respondent also requested the claimant to restore the supply of gas till 15 July to enable it to make alternative arrangement in the meantime. And this Mulad, I'll show Mulad, the arbitrators have commented on this Mulad question. Then Mulad 162, the arbitrator held in that notice of termination, respondent did not urge that it is terminating GSPA for any repudiatory breach committed by the claimant. And in paragraph 54 of the SOD, respondent very faintly urged that in view of breach of contract by the claimant, the respondent was compelled to accept such breach and treat the contract repudiated. Paragraph 54 of SOD also does not spell out how repudiatory breach was committed by the claimant. In fact, there is no pleading in the SOD how repudiatory breach was committed by the claimant, which disabled it from performing its promise in the contract instance, nor is it averred in the termination notice by the respondent. Then, my lord, kindly come to the 163 in the middle. The respondent was also informed. My lord, page 78 in the middle, the respondent was also informed that the MGO clause was never waived by mutual consent. Respondent continued to remain liable for MGO as per agreement. Claimant also made it clear that as per the terms of the agreement, the respondent cannot terminate the same and agreement is valid. Respondent liable for MGO. During suspension period, as per agreement, respondent was also asked to release certain payments. It was made clear respondent requested supply gas can be considered of renewing the bank guarantee of rupees 93 lakh. Full payment was mentioned. Then, my lord, kindly come to 166. Very important. This is important. 166. It may also be noted in this connection that even though the gas supply from SR to the respondent commenced in April 2014, respondent did not mention the same in its termination notice dated 7 July 2014, nor in his representation before the High Court on 8 July 2014. Rather, before the High Court, its representation was that claimant should continue uninterrupted gas supply to the respondent till 15 July to enable it, within quote, to find another supplier. Such representation by the respondent is factually inconsistent with his existing agreement with SR, under which gas supply commenced from 25th April 2014. Respondent's main witness, Mr. Beriwala, admitted in cross-examination that during the time when the termination notice dated 7 July 2014 was written by him, agreement dated 25th April with SR was in operation. Answer to question 130 and 139. He deposed by way of explaining that he did not mention the fact of obtaining supply of CBM gas from SR in its termination notice, since the agreement with SR is a separate one. Such explanation, to say the least, is not at all persuasive. Then, Mulad 167, that's right. It appears that despite its existing arrangement with SR for gas supply, respondent, by not disclosing the said fact before the High Court, obtained an order from the High Court directing the claimant to continue gas supply up to 15 July. Thus, the respondent clearly acquiesced in the continuation of gas supply from the claimant even after his notice of termination, even though it had an alternate source of supply which was not disclosed before the High Court. It has already been noted, not no factual basis for relying on Section 39. Then 168. On an analysis of the above facts, this tribunal holds that the claimant is not guilty of any repudiatory breach as is urged by Mr. Sansach, learned senior counsel for the respondent. This appears from the following facts as well. Then, my lord, it is summarized, my lord, what I've just stated. My lord, A, B, my lord, I'm not again, my lord, C. C, my lord, kindly looks at C. 168C says it respondent has not renewed the bank guarantee of rupees 93 lakhs with the claimant on the ground that MGO clause has been waived and the said bank guarantee by mutual consent need not be renewed. As discussed above, tribunal finds no factual basis for such assertion of the respondent and the claimants have throughout denied an unilateral assertion of the respondent. In the Delhi High Court judgment between the same party and the same GSPA court noted that respondent requested the claimant to waive the MGO clause simultaneously with its entering into an agreement with SR for supply of CBM, paragraph 62 of Delhi High Court. The respondent admitted that those findings of Delhi High Court binding on this tribunal. So, agreement. So, just to just give it just 2 lines in break. Original agreement with me in 2011. Then SR was not there. It's a long-term commitment which he enters into with me. 2014, as soon as SR came in, he enters into a agreement with SR and then has whatever excuse to terminate. And this is the finding of the tribunal to say they are in breach. Now the consequences will have to follow. This is really what we are looking at. Then DE. I'm not because then kindly look at F. This tribunal finds that in the aforesaid circumstances, claimant is not guilty of in breach repudiatory otherwise, in as much as non-payment of security deposit in terms of GSP is to be considered non-payment of dues under the contract by the respondent. Clause 11.5 of GSP, which is important clause in the agreement and which has been treated by the respondent SOD as intended to secure the minimum guaranteed offtake, paragraph 15. It was clearly breached by the respondent and the claimant by suspending the gas supply with notice on the respondent for non-compliance with the bank guarantee clause has not committed any breach of a GSP. Tribunal already held that it has not been established in a case that MGO clause was waived by the claimant. Then, 170. Issuing a termination notice by the buyer for non-supply of gas for 3 days and never justified under GSP. Reference in this connection may be made to clause 4.2 of GSP, which gives the seller option to stop supply of gas to the buyer without notice when an emergency or safety issue arises. Plus answer. Then, kindly come to the clauses are set out in 171. Then kindly come to 174. Therefore, the similar factual finding, that is what I'm showing. Therefore, termination of the contract by the respondent on the alleged ground of non-supply of gas for 3 or 4 days by the seller, when the seller has a justification for doing so, is totally wrongful and in breach of the contractual provisions. So, this is a clear finding with regard to the breach. Then, kindly come to paragraph 188. देखिए आगे देखिए there are several findings 176 several findings saying that because their defense was also that you are in repudiatory breach, because that knows would have given them a right to then put an end to the contract. To that the tribunal held examining the facts, saying that no, I'm not in repudiatory breach. On the contrary, you have breached the respondent. Then kindly come to 188 দেখাচ্ছি 188. Lord, I just want to show 188. For the aforesaid facts and reasons discussed herein above, this tribunal cannot hold that the claimant admitted termination of GSPA by notice date 7 July 2014 sent by respondent. The tribunal finds reasons discussed above holds that the termination of GSPA of the respondent by its notice 7 July 2014 is wrongful and invalid. And then consequently, GSPA is valid and subsequent till 30th April 2034. Then there was a counterclaim by them for recovery of the money. That is F. That is paragraph 189 to 202. And kindly look at 190. Though I don't think any argument was made on that. I'm not very argument to correct. Huh? এখানে argument করো ওখানেও করেনি ফার্স্ট কোর্টও করেনি just to show for the sake of completeness paragraph 190. Before dealing with the various counterclaims indicated above, this tribunal has to keep in mind that it has already held that the respondent is in breach of various clauses of GSPA. A party who is in breach of its contractual obligations cannot legally found a claim on the basis of some contractual provision of which is in breach of, unless his claims are clearly severable from clauses of which is in breach. Tribunal already held that respondent by not renewing the bank guarantee of 93 lakhs is in breach. Similarly, it is in breach of MGO clause and breach of GSPA by wrongfully terminating it. Its counterclaims virtually arise out of these clauses. In other words, party cannot take advantage of own wrong, and it is fully recognized all courts of law, every branch bound by the contract of GSPA, taking into consideration terms of section 28(3), making the what also bound to decide the dispute, submit to arbitration according to substantive law for timing force in India. Then, 191, the claims are discussed. And 199, says, it is not allowing the counterclaim. Then, 200 to 202, is on the question of this billing cycle, which really is not. Now, then, kindly come to very important claimant's relief, which is H at paragraph 205. And this is at page 99. Not today, division this is the important part. Now, 205. The next question, a claimant's relief. The heading. The next question is whether the claimant is entitled to any relief and to what extent. Claimant in SOC has prayed for specific performance of GSPA by seeking a declaration that GSPA dated 11 May 2011 is valid and subsisting and binding upon the parties. Admittedly, under clause 15 of the GSPA, contract shall automatically continue up to April 30th, 2034 and stand terminated thereafter. But the same has been terminated by the respondent by its notice dated 7 July 2014 with effect from 15 July. This tribunal has held for reasons discussed already that such termination of GSPA by the respondent is wrongful and invalid. In a legally binding contract, it is obvious that each party expects that benefit of the bargain which has been struck. In the event the contract is not performed and a breach is committed by one party, party complaining of breach has the right to recover compensation in the form of damages for the loss or benefit under the contract. Both the remedies of damage and specific are available upon breach. The former is a substitutional remedy, where the latter is a specific remedy. Both under English common law, Indian law, damages presumptive remedy, the remedy by way of specific performance granted by way of an exception. Well known that the remedy of specific performance is discretionary one. In the instant case, apart from claiming specific performance of GSPA, claimant is paid for damages in paragraph 48, 49, 51, and 53. It has also argued that its case for damage on account of MGO till the tenure of the agreement, that is April 30, 2034, pleaded in paragraphs 48, 52, and 53, which has not been denied by the respondent in paragraph 83 of the SOD. Paragraph 52, it has pleaded that even after termination of the contract by the respondent, by its notice dated 7 July 2014, it has raised MGO invoices on it from 1st October 2014 for the sum of rupees 3 crore 93, and for the quarter of October 2014 to December 2014 raised MGO invoices for the sum of rupees 4 crore 58. In paragraph 53 of SOC, claimant has pleaded that its claim on account of MGO quantity comes to a sum of rupees 396 crores. The claimant has raised some other claims in paragraph 54, 55, 56, but since those claims pertain to application filed before the High Court, connection civil suit, ultimately withdrawn, does not deal with the claim. Claimant has also paid for certain declaration, also urged respondent cannot deny its obligation. Then 209. Considering the case of the claimant, respondent materials on record, conclusion which have been reached by this tribunal. This tribunal holds that the claimant is entitled to declarations preference clause G, H, and I of its prayer clause at paragraph 63. But considering the nature of the contract, this tribunal, normally very important, in its discretion cannot grant specific performance of the same. Tribunal, however, permits the claimant to remove its underground gas pipeline from the premise of respondent, giving it 7 clear days notice. It is an admitted position that CBS gas, or now 2110 onwards, being a natural product, cannot be stored. It has to be distributed to its consumer, or it has to be flared up. In the order of CCI at paragraph 67, it has been found factually, once the CBM gas is produced, and if the consumer fails to offtake the contracted quantity, GSL has no option but to flare up the gas. There is no spot market for CBM gas where GSL can sell the gas which is not consumed by customer. In paragraph 41 of the said judgment, see, it has been held. Further, GSL has had to flare up 28.40 of the gas produced in 2015-16, as it had no market for the same in the face of competing products. These findings of fact were affirmed also by High Court, as noted above. Learned counsel for the respondent, now kindly see, third time it is being saying, has not questioned the such findings of fact and argued on the basis that the said findings are binding on this tribunal. In fact, the learned counsel for the respondent has no choice other than accepting that finding of fact by CCI as binding in view of section 61 of the Competition Act, which excludes civil court's jurisdiction with respect to any matter which the commission or the appellate tribunal is empowered under the act to determine. Goes without saying, if civil court cannot question the findings, appellate tribunal is also unable to do so. Now, this is an additional fact, my lord, which the arbitrators notice. As against the aforesaid case made out by the claimant and its case of unpaid MGO bills, in paragraphs 48, 52, and 53 of the SOC, the respondent, by dealing with the aforesaid paragraph in the SOC, in paragraph 83 of SOC, did not dispute that MGO bills were raised by the claimant, even after alleged termination of the GSPA by the respondent. Apart from that, in paragraph 83, there is bare denial by the respondent on the case made out by the unpaid MGO bill by the claimant, in paragraph 48, 52, and 53 of the SOC. This tribunal has to decide the case on merits, case of the parties on the basis of the statement of claim defense. Section 23 of the Arbitration Conciliation provides claimant shall state answer. Then 215. Following the aforesaid legal position, this tribunal has to decide the claim of the respondent basis of pleadings between the parties. Respondent, in the course of his argument, sought to urge on the basis of the written notes that the claimant had not suffered any loss by way of flaring up, and they have referred to returns filed by the claimant with the Directorate General of Hydrocarbon, Ministry of Petroleum and Natural Gas. But in SOD, the respondent neither referred to nor disclosed those materials. Well settled that the facts on which there is no pleading, no evidence can be adduced. Even then, it shows from the chart produced by the respondent that there is flaring up. This tribunal is unable for the reason discussed above to accept the respondent's attempt to contradict the finding of CCL that GECL had to flare up 28.48% of gas produced in 2015-16 as it had no market for the same after the respondent terminated the contract in July 2014. So, my lord, clear finding unable for the reason discussed above to accept the respondent attempt to contradict finding of CCI. So, first, my lord, and that's the third place, my lord, I showed that the tribunal has recorded that the finding of CCI and Delhi High Court, my lord, was not disputed. In fact, said that yes, it is binding. With great respect, my lord. Yes, my lord, with great respect, my lord, I submit, my lord, what is, my lord, then thereafter, my lord, left with regard to the tribunal notices that, my lord, one, you're not, cannot dispute, you're not disputing. And two, the fact that, my lord, again, my lord, 28.48. Now, my lord, the care and CRISIL, my lord, is actually, my lord, in its written note of part 4. So, tribunal also did not think it, my lord, necessary to consider that as material evidence. My lord, here, my lord, can you see? The respondent in the course of his argument sought to urge on the basis of his written notes, part 4, that the claimant had not suffered any loss by way of flaring up, and they have referred to returns filed by the claimant with the Director General of Hydrocarbon, Ministry of Petroleum and Natural Gas, but in its SOD. Now, my lord, kindly look at, my lord, this part 4 notes. My lord, it is page 4149. I think, my lord, they are about 20. This is volume 28 also, more than 20. Volume 28. बोलो Lord, in the CCI, Lord, we were also called upon, and that's Lord, what the CCI notes. Our annual report of Lord, 2015. In fact, CCI notes the figure has come from our annual report where Lord, the flaring up is 28 point Lord, that 48%. Now, the tribunal Lord, has relied on that. And I'll show Lord, how Lord, in part 4 where Lord, they have discussed, because one of their witnesses Lord, produces RW2. I'll show that Lord, respondent witness 2. And what Care and CRISIL also says, in fact, Lord, it has, if it was considered, I don't know how it would have helped them. On the contrary, it would have helped me. Because it refers to long-term commitment. Again, 28, sorry. আগে বলে দেওয়া উচিত ছিল ওটা বলে দাও কেয়ার এন্ড ক্রিসিলটা কোথায় এইটা পেজ হলো 4149 দুটো কপি পেজ কোন কম্পাইল ভলিউম দিয়ে দাও আমার তো মার্ক করা আছে ভলিউমটা বলে দাও আগে থেকে বলে দেবো 2209 ছিল আগে এটা কত ভলিউম বললে এটা এখন কত দেখাচ্ছে 128 আর ওটা ভলিউম 16 Which this is right. True. Yes, but it will not consume a lot good. In 2 years it took us before the crime. 1.5 years. They had 4 witnesses. And since I was part of it, I can bear also aware. RW4 was produced after I had produced my witness. And I had strongly resisted. I said, no, you can't have any other witness. And then that turned out absolute harakiri on their part and a boon for me. Well, I'll show RW4 only disclosed all this with regard to SR and all that. We were not aware. So they insisted, no, but I said, no, you cannot. Well, that went on hearing for 3 days where the evidence should be. And the tribunal said, no, we can't shut out any evidence, Mr. Manji. If they want to bring. And one knows all those cases which says that you can't bring your. Because employees came first. And he was the managing director. I said, the managing director can't come after employees have already come. I've started leading evidence. Volume 28 oh. পুরোটা বার করে রেখো তাহলে আচ্ছা অনেক ভলিউম না but you know what is যেগুলো আমরা রেফার করছি না সেগুলো একটু নোট করে রাখুন আবার হারিয়ে যাবে হ্যাঁ আবার হারিয়ে যাবে হ্যাঁ প্লাগ মারা বা কিছু একটা করে নাও can you see this is they had given notes in parts can you see written notes part 4 claimants claim on account of MGO that's what it says then F1 is no loss suffered by this one the index F1 no loss suffered by the claimant F2 MGO claim in not accordance with the contract then kindly come to F at page 4150 MGO bills dated 1st July 2014 and 9 July 2014 has already recovered by the claimant, misleading the Honorable Court into passing the order dated July 8, 2014. So this is the High Court order. On the premises, the entire bank guarantee amount rupees 1.75 crores was recovered on account of price and charges for gas supply. In fact, out of sum rupees 1.75 crores, a sum of rupees 72 lakhs and rupees 11 lakh are the MGO claims for the period 1st April to June 30th and 1st July to 8 July. Respectively, which is evident from the statement being annexed and to SS. Then paragraph 2 is very important. Money is not recoverable for 2 reasons. no loss was actually suffered by the claimant for less consumption of CBM gas by the respondent. Waiver of MGO clauses by way of exchange of correspondence as more fully detailed in paragraph B of the written statement. So, the 2 points I said, the second point was what was urged before the first court. Not so much the first point. Here, the first point is urged more than the second point. Then says MGO clause in nature of a liquidated damages or penalty clause wherever a provision is created for one-sided to recover a specified sum account of breach of any particular term. Not correct, but anyway, this is what the submission is. It is for the claimant who is enforcing MGO clause to establish that in fact it suffered a loss due to the respondent not consuming minimum guaranteed offtake of CBM gas. Case the claimant not given evidence of any loss suffered on account of non-consumption minimum guaranteed quantity to respondent. Only evidence, if at all, it can be called evidence from side of the claimant, bare averment, paragraph 51 of AOE to the following effect. Then, my lord, this is what we had said. I said CBM gas is not an ordinary article of commerce, and the claimant has to make arrangement for supply of CBM gas to the respondent factory and works. I said the claimant does not have readily available market for supply of such minimum quantity of CBM gas, and as such, respondent under an obligation to accept the supply CBM gas for the minimum quantity balance period of the agreement. Not only is the evidence the other side claimant completely bare, lacking particular, also factually. Then, my lord, kindly see. The claimant, so we had engaged the services of CARE and CRISIL for credit rating of the claimant company, which is generally used by business houses for availing bank loans as well as for boosting the concern's credentials and for initial public offer IPO of shares. Please see paragraphs 86 to 90 of AOU of RW4 and para 7 of AOU of RW2. CV4 Sunsers. Read with exhibits EQ and ER respectively forming part of the affidavit of RW2. RW2 has proved the existence of the said documents. Again, my lord, I don't know how, because these are not, my lord, their documents. It's, my lord, document of, my lord, CARE and CRISIL. Please see questions answered. In the claimant's CARE report of October 2014 and November 2014, as well as in CRISIL report of February 11, 2014. Now, my lord, very important. CRISIL's report is, my lord, February 11, 2014. The termination, my lord, is July 2014. 7th July. So, CRISIL report, my lord, is not at all relevant. And claimant's CARE report of October 2014, again, my lord, too short a period. It is still considering, my lord, prior to, I'll show that, my lord, prior to, my lord, July 2014 and November 2015. The details of the orders and commitments that the claimant has and its production capacity has been given. Now, kindly see, my lord, what they say. Details of the orders and commitments that the claimant has and its production capacity is given. It has been stated that the claimant has aggregate commitment of 412 million cubic meter of gas per month as against the production of 88 cubic million of gas per month. Please see CRISIL report of February 2014. Now, my lord, with great respect, my lord, this is as of March 2013. It is of February 2014 is the report. We'll show that, my lord. I'll just show the CRISIL report. How is it relevant? You can't just talk about every evidence and say, oh, arbitrator has not, with great respect. It was not even considered, my lord, worthwhile to be. Then kindly see, my lord, what they say. See CRISIL report of February 2014, exhibit EQ, page 504. Even in October 2014, that is after the respondent's exit, claimant's aggregate commitment for supply exceeded production. Please see CARE report of October 14, exhibit ER, page 516. I'll show that 517 AU of RW2. That this position continued even in November 2015 CARE report. The aforesaid facts appear from claimant's public documents, as in the documents pertaining to the claimant available to general public through internet. They're also corroborated. This is very important. These are also corroborated by the actual production and sales figure, which shows on increase every year since 2010-11, even after termination of the respondent's contract by notice of July 7. This is corroborated by the monthly returns. This is not what was referred to in paragraph 215 of the award. And why I'll show why it's relevant. No, thank you so much. This is corroborated by the monthly returns that the claimant has filed with the Directorate General of Hydrocarbon, giving details of production, consumption, flaring up, and sale of CBM gas. This the claimant is admittedly required to do so as per applicable laws. Please see 83. By application made under the Right to Information Act, the respondent has been able to obtain the aforesaid details from the Director General of Hydrocarbon, adduced as evidence by RW4 by way of supplementary affidavit evidence dated August 18. Comparison of flaring up of CBM gas by the claimant, that is flaring up of excess gas generated by the claimant in the usual course, over the years would go to show that the flaring up of CBM gas in the month of April 14, when the respondent consumed full quantity of CBM gas from the claimant, was 1336 million cubic meter as compared to 0.671 for the month of June 2014. Respondent did not consume any gas between June 2014 and June 21, 2014. The said chart would also go to show that CBM gas flared up by the claimant in the earlier months, as stated below, was much more than that flared in June 2014, 0.671 million, and then they gave the chart. In fact, after the termination of respondent's contract, flaring up of CBM gas by the claimant has greatly reduced. For example, in July 2014, flaring up was only 0.18 million cubic meter. Average monthly flaring up by the claimant for the financial year 2013-14 during this period, respondent consumed full quantity of CBM gas from the claimant was such 12 months as agreed, that is their consumption. So, this is how they rely upon the evidence of care, CRISIL, and the returns filed with hydrocarbon. Now, with great respect, I say this whole approach is wrong, is erroneous. Because for me, like I said, when I started my arguments, for me not to get any damages, you will have to show that I had no CBM gas. I had no CBM gas to supply. So even if there is a little bit of flaring up, and that's what the learned single judge also, with great respect, when I show, has also. So even if there's a little bit of flaring up, that is good enough. I'm going one step further. I'm saying unless you show that there was a finite quantity of gas which is available to me, and that was exhausted, I would have want more. Of course, you're causing me loss because you're making me lose that opportunity. You're making me lose that opportunity, and I'll show our reserve is about 2.4 trillion. I just have to dig a well and supply gas. And all because the natural resources, I have to pay go on paying royalty on the amount which is already estimated to be available. So the approach is not correct. We have gone further. Rather, you have shown that there's been some flaring up. This is their argument, their admission. And that is what now looks at page para 215 where we were at page 103. Following the aforesaid legal proposition, this tribunal has to decide the claim of the claimant on the plane. Then it is well settled that the facts on the plane. Then even then, sorry, before that, I'm so sorry, respondent in the course of his argument, that is third line. In respondent in the course of his argument sought to urge on the basis of its written note part 4. It's noticed that the claimant had not suffered any loss by way of flaring up, and that they have referred to returns filed by the claimant with the Directorate General of Hydrocarbons, Ministry of Petroleum and Natural Gas. But in its SOD, the respondent has neither referred to nor disputed. It is well settled. Then even then it shows from the chart produced by the respondent that there is flaring up. This tribunal is unable for the reason discussed above to accept the respondent's attempt to contradict the finding of CCI that GECL had to flare up 28.48% of gas produced in 2015-16 as it had no market for the same after the respondent terminated the contract in July 2014. Well, we also have the primary document, but since it was not before the arbitrator, not before the first court, I'm not showing. But that's my report, which is noted in the CCI order and the Delhi High Court. And they accepted the findings. It was never called in question. So now, the thing stands. Has the arbitrator, with great respect, has the tribunal gone wrong in giving me, damages, when admittedly now, at least on the finding, there is a breach of contract, which is long-term 20 years contract, and decided that I will get only a part of the MGO, which I'll show 80 Bridgepal. There also they had to guess estimate really as to what is the damages. And very important, I was going on raising my MGO bills. That has also been noted. So as soon as the termination is set aside, contract revives, which the learned arbiters have also held. And I've raised MGO bills. In fact, I would think, and I would have been, we are not being, in that sense, over greedy or over. The MGO bills which are being raised under both the Bihar State Electricity case as well as the Orissa Electricity, they said even after discontinuation, you're entitled to get that payment. And that would have been 236 crores as on that date. Sorry, 396. No, 396 the Purota. For up to 2034.
You have got 58.
58. That's 15% of that amount. I'll show that. So this is where now kindly come back to that notes again, I'm sorry, and then I'll just show the so in the notes 4155 will find they have given the chart of flaring up is given. Now just kindly read with me paragraph 7. And at page 4156. The percentage of gas, CBM gas, flared up by claimant as compared to production during 2013-14. These are last 5 lines of that paragraph. Was 9.73 as against 5.41 for 24-2015. Percentage of total CBM gas flared up as against sale was 12.49 during 2013, whereas it was only 6.7% during the year 2014-15. So 2 things are happening. One, their own admission there is flaring up. And the percentage is irrelevant. Secondly, in the CCI funding, it is much more. And which is based on my annual report. Because they produced the 2013-14 annual report. They did not produce the 2015-16. 2013-14 they relied upon. Now, kindly take the CRISIL and CARE report which will find at page 2209. EQ and ER. EQ is the CRISIL. 16 নেই বললে এত এত এক্সারসাইজ করে সেটা এত কষ্ট করে বার করলাম 15 আর 16টাও দরকার 16টা দরকার 16টা সরি শুধু 15টা কোথায় মার্চ তারিখ No, 2209. I'm sorry. So 2209, Malad, kindly look at Malad, the third paragraph there. The CBM block has an estimated reserve of, Malad sees, 2.4 trillion cubic feet of original gas in gas in place as verified by independent consultant. It is already in the production phase. 157 drills have been wells have been drilled as of December 2013, and 50% produce gas, while the rest are in the dewatering stage. Going forward, kindly see, more wells are expected to move past the dewatering and such, which should increase gas production significantly. The company has put in place its own pipeline infrastructure in Raniganj, which helps it to reach customers in a region divided by a gas pipeline. Moreover, the industrial belt of Asansol, Raniganj, Durgaon, served by this has a high gas deficit. The grid is constrained by the capital intensive nature. Then, can you see the grid is constrained by the capital intensive nature of the business? Also, the pace of development of other two blocks is slow. Asansol explosion is answer. Then kindly come to Well, 2212 at 2212 sees total typically CBM gas and long gestation period multi-phase development process involving pouring in sensors. Then kindly see presence. This is very important. This is what they relied upon. GECL's operational Raniganj South Block is situated in the vicinity of Asansol, Raniganj, Durgapur industrial belt. These cities have industrial activity with significant fuel demand, such as steel plant, carbon black, glass and chemicals industries. Prominent companies in the vicinity include the ISCO steel plant, Durgapur steel plant, Alloy steel plant of SAIL, besides Alstom projects, Graphite Limited, and Philips Carbon Black. Then kindly see, this is what was as of March 2013. The company has aggregate commitment. As of March 2013, company had aggregate commitments to purchase up to 412 million of CBM gas as against 88 million of cubic meter of production in FY 2013 as per DRHP. Now, my lord, I'm so sorry, my lord. May I just trouble my lord with that written notes? 4153, the other volume, my lord. Can you see B? 2030 to leave out. Volume 28, my lord, the volume 28, which my lord was
28. Yes.
Yes, my lord, that notes which because my lord has seen, my lord, this as of March 2013. So, my lord, with great respect, my lord, in the notes, my lord, kindly, my lord, look at the notes. in the middle, my lord, 4153B.
Yes.
So same figures are given. It has been stated that the claimant has aggregate commitments of 412 sons of sewing as per month, production of 88. Where is March 2013? And that's what's been relied upon. We are not concerned about March 2013. How do you know how much my production capacity increased? So you have to have relevant evidence to come and make the point that no, because this X affidavit was not considered or X or Y report was not considered, therefore the entire award should go. Because you take this line, you give the same figure. It has been stated that the claimant has aggregate commitment of 412 Malat sees. It starts with, as of March 2013, company has aggregate commitments to purchase up to 412 million, million MMSCM, which is standard cubic meter. Million standard of CBM as against 88 million of production in FY13. Why miss out on FY13? Be fair. It's not, that's why my submission, not relevant, not considered. Arbitrators have only gone on the basis of that there being a flaring up, that is good enough to show losses by their own admission. Because the contract was to be performed. That's why I said the whole basis which is being pursued, which was being pursued before the arbitrators and also today, is wrong. Because you'll have to show that today my entire 2.4 trillion cubic meter of my resource reserve is gone. Then you can come and say. It's like, sorry, I keep repeating this example. If one has 10 cars or something which is finite, then I understand. Yes, you come and say, sorry, you could not have given it. So no loss has been suffered. But here not so. Then kindly look at this. The next in the same, I'm sorry, I'm taking back to 2312 and 2313. Expansion by sale to augment demand. The next paragraph says demand is going to increase. It says expansion by sale to augment demand. Let's read this. I would have had your demand and sales demand. Sales steel plant in the Asansol are expanding, which should increase demand for gas in the area as well as new units are designed to use gas or fuel, for instance, sales and such. Then kindly see, we talk about lower competition in the region. Then at 22, then the care report. 222. No, 223. That is the care report. In fact, sorry, may I just, before I show them, may I just trouble once? Volume 20. I'll just this is one question.
No, that's all right. As they find out the volume, a completely irrelevant question. But when you talk about these cars, this example, what kind of car you have in mind?
Usual, either may not know them, Marutis or Hyundai's, or good Indian, Mahindra.
I say no further.
Sorry.
3246.
3246.
22.
No, this is Malad RW4. The Sean, two. Very well. Malad RW4, Malad the Managing Director's Malad cross examination. Question 206. In fact, Malad, may I just show 204 onwards. You note production of CBM gas is a natural phenomenon. Production cannot be increased or decreased. I am not aware of the technical association. However, like to reiterate facts mentioned prior 83. Then 205, do you know that CBM gas cannot be stored in excess? My answer is same. Then 206, you must also be aware that if a customer on the claimant does not take the CBM gas which has been contracted for, then this would have to be flared up. I would like to see paragraph 10 of my affidavit of evidence, also exhibits EQ and ER, disclosed in the affidavit of evidence of Shubhashi Shaw. EQ and ER, Malad, are the CRISIL and Malad, the CARE reports. I want to rely on these documents as the claimant has declared its credit rating report tie up with the customers in much higher quantity than its production. I am not in a position to comment on the technical aspect of the production. However, as part of business prudence, claimant would always be in a position to divert the gas to other customers. In its credit rating report of CRISIL, annexure EQ page 504 of affidavit of evidence of Shubhashi Shaw, claimant has declared, now can you see this portion is, as of March 2013, claimant had aggregate commitment to purchase up to 412 million cubic meters of million MMSCMM CBM as against 88 MMSCM production effort. So, Malad, this with great respect, Malad, CRISIL, so far as this is concerned, and this is what is quoted in the notes, is absolutely irrelevant. Why is February 14 at all, the report of February 14 at all relevant? We are talking about post July 2014. And how is the effect, Malad, coming after that? If, Malad, at all that has to be considered as a basis for denying me, Malad, damages. Now, Malad, may I come back to Malad? So sorry, Malad, 2223.
Wait, no.
The same, Malad, volume 15, which was, Malad, being considered.
Volume 25.
Malad, in 2223, Malad will find credit risk assessment is there, then total income increased by approximately 30%. All that, Malad, is there. Again, this means nothing. Because if I had supplied to you, it may have been 40%. So that's why I'm showing, Malad, this is not relevant. To make such an issue with regard to saying that, oh, this had this been considered, then the arbitrators would have completely not given you any damages at all. And that has to be, Malad, the relevancy test for non-consideration of any evidence. It has to be material. Kindly look at 22224, establishing marketing and infrastructure basis. Establishing market, and Malad has that, Malad, establishing market, and this is 2224, last portion of that, Malad. GECL's operational Raniganj South Block is situated in the vicinity of the Asansol Raniganj Durgapur industrial belt. These cities have industrial activity with specific significant fuel demand. Catchment area includes steel plants, carbon black, glass, and chemical industries. Proximity to these markets has allowed the company to secure supplies for 1.21 million surcharge as on March 31, 2014 against 1.14 as on March 31, 2013. By comparison, Kinesis GCL produced 121.13 of CBM during FY14, thus providing with considerable opportunity to increase production and sale of CBM. Company has executed, now Kinesis, various long-term and medium contracts along with minimum offtake guarantee with customers which provide long-term revenue visibility. Tenure of contracts for top 10 customers range from 2 to 3 years to 20 years. Then, to support the existing contracts, company has adequate infrastructure base for gas transmission, comprising existing 77.2 kilometer of 12-inch high-pressure pipeline, the ultimate capacity of 100 surcharge, operated 45. The company is also gas gathering stations, total surcharge.
What is the date of this report?
Well, this is of October 14. Well, it is written at on the left hand side, perhaps in the in black, it is written in where it starts volume 15 2
October 14.
on the October 24. In fact, kindly also look at 2224. What I showed just before that, there is a heading called increase in reserves. Increase in reserves, just in 2224 only. GACL's Raniganj South Block has an estimated original gas in place of 2.44 trillion cubic feet as against 2.4 TCF as on February 2013, and net IP and 3P reserves of 77.9 billion cubic feet as of December 13, according to Advanced Resource International. So it is also increased in December 2013. So I'm on the question, I'll just show another and then make my comment on this. Where's the 215? In at 2 to 320 is that? Expansion of in fact, the 2225 which I was reading, after to support the existing contract, the company had adequate infrastructure. Then, 3 paragraphs later, in field development and inherent risks pertaining to exploration production business, then expansion project 124 wells is estimated total cost of rupees 1200 crores. So, expansion project is also there. And in fact, in this report also we recognize that SR has come in. Then the next one is November 2015. It starts at 2229. Nothing here. This is November 2015. And it also talks about lower offtake from the largest customer, Steel Authority. Then at 2230. And then it ends at 2234. nothing significant. So what I'm saying is, one has to, apart from where they pointed out that 88 cubic meter was the production and 412 was the committed, is as of March. That's the only significant thing which I found. But that was in 2013. How is that relevant? With great respect, it's not been considered. 2015, there's nothing. So non-consideration of this does not in any manner change the outcome of the award. Because this was what was sought to be portrayed, saying that nothing which has been mentioned about this. And what was relevant, the return with regard to hydrocarbon, that has been considered. Their own cases, there has been flaring. Now, kindly come back to the award. Blank actually.
Yeah, done. It is sure.
We were the award, 215.
Yes.
Actually, sorry, just give me. Technology sometimes क्या है वो एक सेकंड at 215 I had shown at page 103. Then 216. This is very important. In fact, 216 where Kailash Nath is referred with great respect, that has absolutely no considerations over this case is concerned. And similar respondent has also relied on the judgment of the Supreme Court in the case of Kailash Nath Associates versus Delhi. Development Authority reported in 2015 4 Supreme Court cases 136. In that judgment, the learned judges of the Supreme Court held in paragraph 33 and that section 74 of the contract is sandwiched between 73 and 75, which deal with compensation for loss and damages for breach of contract, which a party may sustain through non-fulfillment of contract. After such party rightfully rescinds such contract. Court held compensation is payable for breach of contract under section 74 only where damage or losses caused by the breach. Relying on the aforesaid observation, learned counsel for the respondent urged that in this case the claimant has not suffered any loss. Now, Kailash Nath, remember there was a forfeiture clause in a contract. The earnest money deposit was forfeited. In that context, the court said that sorry, you really can't claim the entire thing because it becomes penal in nature. But such a contention is clearly contradicted by the factual finding of CCI that GECL had to flare up 28.48 of the gas percentage of the gas produced in 2015-16 as it had no market for the same. Therefore, the principles reiterated in Kailash Nath have been satisfied in view of the aforesaid finding by CCI, which is binding on us. Then next come very important, quantum of damages.
Mr. Mitra also repeated a number of times that this 28.4% is not a finding of the CCI. It is recording of your case.
Which has been accepted by the Delhi High Court also. And that's why, I showed the findings or whatever is there has not been contradicted. They also say, gas was flared. They say, 5.9% according to them, in 2015-16. That's their written notes. Recall,
Yes, yes.
It's 8.9, then they say 6.7.
Extent of flare, percentage really loses. Percentage loses relevance to a great extent.
Absolutely, my lord. With great respect, my lord, that's what, my lord, and with great humility, my lord, I submit. The principle of law, my lord, we should not, my lord, go in a way, and this is my humble submission. It's not a question unless you are able to show, to take me out of my right to have damage, you have to show that this was over. Otherwise, it doesn't happen. If the contract would have continued, I would have produced more gas, supplied you with the gas, and got my price. You are one of my long-term commitments, 20 years. 20 years. You'd had to continue for 20 years. Principle says I have to be put back into the same situation as if the contract had been performed. To that, my lord, I am given only 15%, considering 80 Bridgewall. Though, my lord, I agree, my lord, Bridgewall was in a different, it was again with regard to performance of a contract, but my lord, different. So, my lord, it's correct. My lord, what has fallen from the court, my lord, that's also my submission, saying that that really loses its significance. 1%, 2%, 20%. My lord, if today, my lord, if I had lost, flared up, let's say, my lord, 50%, would they have compensated me for 50%? No. How am I bothered? You can't market your gas. You can't sell it. I am not responsible. Had they been, today, no minimum guarantee, and that's why, the logic of minimum guaranteed output becomes very relevant. And we can't deal with, breaches of contract, in a very casual manner. I've done no wrong. You came for supply of CBM gas. We entered into a long-time contract, negotiated contract. We are both business persons. I have arranged my affairs on the basis of that. I have, let's say, I put my, has seen that. That's why I showed that, in fact, if we had relied on the CARE report, it would have also, been in our favor, where it is noted that there are long-term 10 top customers, 2 to 3 to 20 years. He's obviously was one of them. So that is where, Mr. Mitra's, that causal connection is not there. And in the, it's correct, in the CCI, it appears, either it's my submission or, the first part of it appears to be either a submission or a finding, we are not very sure. But I have, that's why I said, I have the data with me. That's my, reporting in, 2015-16. In the annual report. If it was contradicted, we would have again produced evidence here. Now they are contradicting. I am also not entitled to show that they are wrong. Finding. No, it's very important. Sorry, my lord. Perhaps, my lord, it is a finding, my lord, because it says, my lord, I'll just want to read out. I'll show that, my lord, when we come, my lord. This is paragraph 41. It starts with, lastly, on the issue of dominance, it was submitted that GECL has no financial strength. That's the submission. Then after that, it says,
What are you reading?
my lord, the CCI order. I'm just reading it, my lord. I'll place that in detail. That's why I'm just the DG has relied on, that's the Director General who makes the, has relied on financials as reported in the annual reports to show GCL's financial strength. Mere profitability on the books of account cannot lead to an inference of dominance. A more accurate measure is the net cash generation, which has been negative till date for GCL. This shows that GCL is still in the process of recovering its initial capital investment. Further, GCL has had to flare up to 28.48% of the gas produced in 2015-16 as it had no market for the same in face of competitors. And Malad, in their notes, they Malad only give the figure of Malad first 2013-14 and Malad 2014-15. 2015-16 Malad they do not give.
That is the financial year.
Yes. That is the financial year. So it has a long-term effect. Today, Malad, I might find Malad one market who might come Malad for, let's say Malad, someone comes and says, no, give me gas supply for 6 months. Obviously, flaring up will be less. But I do not have that commitment for 20 years. So therefore, Malad, when Malad, Mr. Mitra says Malad that this 20-year Malad, it is first not relevant. Secondly, Malad, that is also Malad something which has been accepted by them. And that appears Malad from my balance sheet, the annual reports itself. Because you are relying on a report of CARE and CRISIL. It's a report that is also not proof. Why are you using it against me? Because you say I have used it for my IPO. You're also relying on my annual reports, which is 2013-14, which is on record. So whatever I have represented, you're relying on. Therefore, also in the same vein, you also rely on my other annual report from which DG has found that it is 28.46% or.
This is your annual report for the year 15-16.
15-16. That's what the DG is finding. Or that's been noted in the CCI. Not DG is finding, but noted in the CCI. And they also rely on my statutory returns to show there's some flaring up.
Oh.
And which is what was accepted by arbitrator at paragraph 215. Paragraph 217, I think I'll be able to finish this, the award and the next day, I'll just show the cases and 217. The next question is what will be the quantum of damages which can be awarded by this tribunal? In paragraph 48 of the SOC, sorry, has that page,
Yes.
SOC, the claimant has claimed towards MGO rupees 6,98,000 and rupees 61 lakh. If one adds these two amounts, it comes to rupees 68 lakh 0625. If from what we deduct the balance of 63,237, which is available as shown in paragraph 48, then it comes to rupees 67 lakhs 43,000. If with that we add the amount pleaded in paragraph 52 for MGO invoices raised on October 1, 2014 for the sum of rupees 3 crore 93 lakhs and the other MGO invoices raised by the claimant for the quarter of October 2014 to December 2014 for the sum of rupees 4 crore 58 as pleaded in paragraph 52 of SOC, then it total comes to 9 crore 1990 288. So this is up to when the statement of claim was filed. Then the amount pleaded in paragraph 53 of SOC for the MGO quantity for the invoices commencing from January 1, 2015 till the tenure of the agreement dated April 30, 2034, the amount comes to rupees 396 crores. If all these figures pleaded in paragraph 48, 52 and 53 are added, then it comes to rupees 405 crore 63,13,168. This calculation has been made by the claimant based on 78-day circle. Tribunal accepted that claim of the claimant, but held that the cycle is for 75 days. Considering the above, the claim is reduced to 390 crores. Now, kindly see, there is a total application of mine. Everything is added, what I've claimed, so that's 405 crore. Then, because the cycle was held against me.
What cycle is this? What is this cycle?
This is for the period of calculation. We had said, it is 78 days, which means it would have given me a higher amount of MGO. But there was a handwritten cross out saying it's 75. So that was held against me, saying that no, sorry, we are accepting 75 days. The computation of the MGO. So in that it was held, cycle is for 75, considering the same claim is reduced to 390 crores. Then sees, now this tribunal has a discretion in the matter of awarding damages. In exercising its discretion, tribunal has to follow the guidance from the decided precedents of the highest court. Thus, the tribunal accepts the standard form of damages awarded by Supreme Court in two of its decisions. First, in the case of Muhammad Salamatullah and others, and the other case is that of Messrs. A.T. Brijpal Singh and others versus State of Gujarat. Following the same principle in both the judgments, 15% of the amount claimed as damages has been assessed as standard, which has been followed by the courts. Following those principles, this court also allows 15% of the aforesaid amount of 390 crores, and which comes to rupees 58 crores, of which the rounding figure is 58,50,45,169. The above amount considered in the previous paragraph is the reasonable assessment of damages by this tribunal on the value of the balance price of MGO, which the claimant could not receive by reason of the illegal termination of contract by the respondent. Applying broadly the principal case of Brijpal Singh, this quantum of damage is decided. This principle is Brijpal has also been approved case of MSK versus State of Rajasthan. Even though the claimant has claimed interest in the rate of 15%, here also, the tribunal may exercise in discretion, considering the fact the matter went on for some time in view of the pandemic situation. Tribunal grants interest rate of 7% on the aforesaid amount of 58 crores, month of February 2015, since the SOC in this matter was filed on 30th January 2015. Award, then the award is filed.
So we'll stop here.
Yes.
Lekho. Mr. Banerjee, learned senior advocate appearing for the respondent, resumes his argument but does not conclude. Paragraph, list the matter once again next Monday.
Friday is a holiday, but it's Friday.
But the interim order has to be extended,
It is still till
end of August. End of yesterday, it was till end of August.
we'll make it till the disposal of the appeal.
Yes.
The interim order that was in operation till Gotokalet date, the August 31. Sure about that? Mama?
Yes, it was in recorded in Lordship's order of 28th July.
Very well.
Stands extended till end of August.
And reinstated and shall continue till the disposal of the appeal.
Yeah. I'm grateful. I think it's done. On commercial, 3:30 PM fixed matter, item 94 to 100. We have formula.
You are assisting Mr. Mitro.
And Mr. Thakkar, yes.
Yes, you have completed.
We have not completed as
Not
such. but-
completed. No, they have not. They said 10 minutes more.
Yes, yes.
No.
There are other appellants also.
Mr. Thakkar mentioned this in the morning. We said we are not going to adjourn.
Yes.
Too many parties are involved, and with great difficulty we fix matters.
Right.
So then who will make submission, Mr. Mukherjee, today? Who will make submission?
My lord, if they want to, my lord, otherwise we'll start.
But Mr. Thakkar said he's in personal difficulty. Please give me some time. Then we'll hear Mr. Thakkar later what to do. We can't waste this time.
Could I then in that event, my lord, argue on one point and thereafter
Yes. Then you conclude on behalf of the
the opening submissions in case anything is left, my lord, we shall in the later. But otherwise, my lord, this is I believe this point should be made in the opening submissions
Yes.
for them to deal with.
Yes.
Companies Act 434. My lord, one point which I would like to, my lord, make on the last proviso, which has possibly not been argued by us. It's a new point which we want to, my lord,
Last proviso to 434.
to 434 one. Yes.
Not argued.
No, this is a point which is not argued. I'll indicate, my lord. It's on the question of jurisdiction. একটু জজ সাহেবকে একবার। But if your lordship kindly takes the Companies Act, না এটা না, Companies Act. Companies Act 23. My lord will kindly see the first proviso, the last proviso, my lord, to section 434(1). But we had placed this proviso for the submission, who is a party to the proceeding. But I am not on that, my lord. That is one submission which we provided further that any party or parties to any proceeding relating to the winding up of company has a lordship. That submission was made with regard to who can make submission. But my submission is, if lordship kindly reads on this provision, provided further that any party or parties to any proceeding relating to the winding up of companies pending before any court immediately before the commencement of the Insolvency and Bankruptcy Code Amendment Ordinance 2018 may file an application for transfer of proceedings, and the court may order such transfer of such proceedings to the tribunal, and the proceedings, kindly marks this, and the proceedings so transferred shall be dealt with by the tribunal as an application for initiation of corporate insolvency resolution process under the Insolvency and Bankruptcy Code. So, my lord, what happens to the transferred application? This is what this later part of the proviso deals with, that it shall be taken as, my lord, initiation of a corporate insolvency resolution process under the Insolvency and Bankruptcy Code. So this is how it is to be dealt with. Now, my lord, if your lordship kindly takes a look at, my lord, the Insolvency and Bankruptcy Code and, my lord, section 4. Section 4, and there's this recent notification, not recent, 24th March 2020. আচ্ছা, আরেকটা কপি দাও। So your lordship would see that section 4 of, my lord, Insolvency and Bankruptcy Code, there has been a amendment where the threshold limit has been, my lord, fixed at 1 crore. Now, my lord, your lordship has seen that this will not be treated as a proceeding under the Companies Act, the transfer proceeding. It has to be treated as a initiation of CIRP, corporate insolvency resolution process under the Insolvency and Bankruptcy Code. Now, my lord, all the applications, the company petitions which were pending, my lord, your lordships, my lord, we had placed page 177 of the second volume with regard to, my lord, what all payments have been made. If that page your lordships are pleased to take a look at, kindly sees what are the values of the company petitions pending. None of them are in excess of 1 crore. My lord, I'm sorry, page 170 is to second volume. If you may I please? None of the company petitions.
We remember, yes.
Yeah, my lord, it's more than 1 crore. So, but this is like a situation where an operation mismanagement, I'm giving an example, not in our case, like an operation mismanagement is complained of, but because of, my lord, lacking in the requisite of 10%, one cannot go before the CLB or the company, National Company Law Tribunal. If one's shareholding is less than 10%, then no matter where, even if the complaints of an operation mismanagement, the jurisdiction of NCLT is not attracted under the present provisions of 244 or previous provision of section 399. He has to file a suit. So, drawing analogy from that, in my humble submission, there is a pecuniary jurisdiction lack in the event this proceeding are transferred to these proceedings, are transferred to the Company Law Tribunal. Now, these proceedings, these the notification prescribing the threshold limit came on 24th March 2020. The order was passed thereafter. So, as on the date when the order is passed, that court or that forum lacks jurisdiction.
But in respect of winding up petitions presented prior to the notification coming into operation. When were the winding up petitions filed? All pre
2016, 2017, 2015, pre. But I am on the issue that when the application for transfer was made, by that time already notification was there. So, kindly visualizes it from another viewpoint, in my humble submission.
IBC আছে Yes.
My lord, your lordship has seen, my lord, section 4. This is this notification which I handed up, by which the threshold was increased with effect from 24th March 2020. Now, my lord, one other thing, my lord, none of the judgments of the Supreme Court or any of the judgments of our High Court or any other court had considered this issue. This is not a point which is considered anywhere. My lord, if this is permitted, then If this is permitted, then a court which inherently lacks jurisdiction, somebody would be filing a matter elsewhere and have it transferred to that court. This lacks jurisdiction because of the threshold limit not being there. Like a 241, 242 not being there because of the threshold limit of 10%. So, my lord, in my humble submission, my lord, going by this, the language that this would be treated as initiation of CIRP. So, a CIRP is initiated only by the adjudicating authority under the, my lord, Insolvency and Bankruptcy Code. The National Company Law Tribunals wears two hats. One as an adjudicating authority under the IBC, the other as the tribunal under the provisions of the Companies Act. So here the adjudicating authority's hat, well, it derives jurisdiction in my humble understanding, subject to my lord's testing it, of course, would be from the powers under the IBC. Now, if that is not attracted, well, then, well, in my humble submission, that proceedings cannot be transferred. Now, as on date, your lordship, an amount of 82,280 is outstanding. So what is being transferred is 82,280 rupees. Otherwise, the CPs have been paid in full. One has been withdrawn, the other satisfaction payment in full recorded. So what is being transferred is a CP of 82,000 rupees and my 466 application, which is CA 203 of 2017.
Yes, Mr. Gupta.
Yes. My lord, now joining the conduit which my learned senior was submitting on why the discretion has been given to the court. But this really, my lord, is one of the other ways, my lord, why discretion has been given to court to see whether this can be transferred. That is why the language may has come in by way of the proviso, and the compulsory, or so as to say, my lord, a mandatory wording of the principal proviso has been watered down. So this is one of the other situations which can be considered by a court before, my lord, embarking upon the journey of taking the decision to transfer. So whether the court has the jurisdiction would also have to be, my lord, looked at. Those are
Anybody who is supporting you, Mr. Bachawat was appearing for whom?
My lord, Mr. Bachawat, my lord, is in a connected matter. My lord, there the issue is much narrower. My lord, a suo motu transfer by the High Court, my lord, without any application by any creditor. My lord, our contention would be that, my lord, there are two covered judgments, my lord, of the division bench, which said that they were, my lord, similar matters. My lord,
You are resisting transfer or supporting?
resisting transfer.
Very good. Then you are on this side. No, sorry.
He's on our side.
Yes.
He's on your side, yes.
And Mr. Banerjee, Mr. Ratnanko Banerjee is partly on our side. In
Yes,
one of the matters,
correct.
he is partly resisting us.
Correct.
One of the matters he is opposing.
But that is the issue, Malad, where there was no application made. Because this is again, Malad, narrower, because here, Malad, we made an application. Yes. Malad, Mr. Mukherjee, Malad, is.
Then you give us those two judgments. Conclude. This can't carry on indefinitely.
My lord, if we are permitted, my lord, 15 minutes on, my lord, anytime
When
next week.
this any day thing doesn't work, sir. Today is that day. We have fixed it at 3:30 today. Give us those two judgments. Give
My
us.
lord, the judgments are not with me, my lord. At the moment, it's annexed to my petition.
এইভাবে কোনো মামলা হয়?
Flight Delhi. My lord, gone.
Then we'll hear you. What to do? We have no choice.
My lord, our case is one where there is an application,
Yes.
where my lord, the order was passed.
The application is where there is no
Yes.
application. With a suo moto law, the Honorable Court was pleased to direct it to be transferred. There was no application.
So if you want to argue, argue. You're all resisting the transfer. So finish that off.
The suo moto is really a subsect point, my lord, whether
My lord, that can actually wait, my lord. Mine is, my lord, with an application.
That is true.
So, my lord, I can conclude my submissions.
Do that. Let Mr. Mukherjee conclude.
Now, my lord, basically, my lord, 3 points, my lord, have been argued, my lord, by my learned friend on the matter of principle. My lord, the first point is that, my lord, I have made a statement that I stand outside the winding up. Therefore, at my instance, there cannot be, my lord, a transfer to, my lord, the, my lord, adjudicating authority, or that, my lord, the National Company Law Tribunal. That's number one. Number two, my lord, is there is a discretion, my lord, which is now given, my lord, for transfer. And in this particular case, discretion should not be exercised in favor of transfer because of irreversible steps, my lord, which have been taken. And, my lord, the third, my lord, is that, my lord, I have filed, my lord, my section 7, my lord, after, my lord, passing of this order. So this should have, my lord, no, my lord, impact at all. My lord, if there is to be a stay, it is to be, my lord, of the section 7 and not, my lord, an order, my lord, of, my lord, transfer. My lord, these are, my lord, the 3 points, my lord.
And the fourth one today.
Yes, my lord, I'll deal with that, my lord. Now, my lord, the fourth one, my lord, is the notification, my lord, which is, my lord, will have effect, my lord, on a statutory provision where, my lord, discretion has been given. My lord, these are, my lord, the 4. Now, my lord, the first point, my lord, which I wish to make, my lord, is, my lord, a winding up order under the provisions of the Companies Act 1956, my lord, inures unconditionally to the benefit of, my lord, all creditors and contributories. So, my lord, the fact, my lord, that I am outside the winding up and not a party, my lord, to, my lord, the winding up proceedings is, my lord, wholly without basis. Now, my lord, why do I, my lord, say, my lord, this? My lord, your lordships would recall, my lord, that when a winding up petition is passed, my lord, there is only the petitioner. And, my lord, first step is, my lord, it companies in the cause title, there's no respondent. My lord, there's a petitioner.
In the matter of company,
Correct.
then only petition.
Petitioner, that's it. Because, my lord, it's a practice developed in our courts, my lord, that before, my lord, advertisement, my lord, a notice is given to the company to resist. So the usual direction was first service on the company, my lord, which was, my lord, the first fee, my lord, that a junior would earn without being questioned. Only question asked was whether the claim is over 500 rupees. My lord, this is recognized in all the cases. Now, my lord, the second is the company appears and, my lord, seeks time to file affidavit to resist, my lord, an admission of the petition. Now, my lord, that is the second fee, my lord, that, my lord, the junior appearing for the petitioner earns.
that's a difficult fee. We have always been posed with a question. Affidavit is not your birthright. What are your defense?
No, that was before one particular judge. My lord, now, my lord, that, my lord, happened. Then, my lord, after affidavits, the matter would come up. My lord, if, my lord, a bona fide dispute, my lord, is not, my lord, presented before the court, then, my lord, it is, my lord, admitted. But again, my lord, a chance is given. Before advertisements are published, if you pay this, either at one time or discretion of the court in installments, then we do not have advertisement. Now, my lord, moment, my lord, there is a default there, or, my lord, they are unable to pay, my lord, normal course, sometimes court extended the time, was, my lord, that there would be an advertisement, my lord, of the petition. Because, my lord, it is then only that, my lord, hearing started under the company's court rules. My lord, in the winding up petition, my lord, advertisement was mandatory. It was not mandatory, my lord, under 397, 398. Because if all shareholders were already before the court, there was no need, my lord, for, my lord, advertisement. Because, my lord, and why is this? Because, my lord, a winding up order, if passed, my lord, has to inure to the benefit of all creditors. Now, my lord, kindly have a look, my lord, at, my lord, the old act as well as the new act. My lord, kindly take, my lord, the 1956 Act. 56 Act, do you have? I have. 2012. Okay, does it have it? আছে নিশ্চয় দাদা আমি বার করে দিচ্ছি section 447 just give it section দেখো আছে এটা section 447 থাকবে
Yes, effect of winding up order.
yes ও আছে
এটা কি to fellow but
now my lord may I my lord read this my lord once kindly see my lord my lord 447 an order for winding up a company shall operate in favor of all creditors and of all the contributories of the company as if it had been made out on the joint petition of a creditor and of a contributory. Contributories are the shareholders, my lord. So, my lord, it has to inure, my lord, to the benefit. My lord, recognized statutorily, my lord, this section, my lord, has been, my lord. So, my lord, I am, my lord, after advertisement, my lord, whether I make a choice to stay outside winding up or not, makes no difference. My lord, this has to inure, my lord, to my benefit. Now, my lord, what is meant by, my lord, staying out of winding up? My lord, winding up order, unless, my lord, stayed under section 466, my lord, has to ultimately result, my lord, in the assets of the company being sold by court. And, my lord, the, my lord, distribution of the sale proceeds, my lord, first, my lord, to secured creditors and workmen. That's, my lord, section 529 and 529A of the old act. Then, my lord, the priority, my lord, of distribution, my lord, is, my lord, provided for in the act, what we may call the waterfall mechanism. First, my lord, priority here, statutory dues, then, my lord, all the dues, my lord, and, my lord, priority is, my lord, expenses incurred for beneficial winding up of the company. So if the liquidator, my lord, is spending any money, my lord, for, my lord, maintaining the company's assets, that has to be. Now, my lord, coupled with this, now kindly see, my lord, I stay outside winding up. But, my lord, section 446 says, you have to come to court to obtain leave. My lord, kindly have a look at, my lord, the old 446, my lord. My lord, 1 and 2, my lord. When a winding up order has been made to the official liquidator, or has been made, or the official liquidator has been appointed as provisional liquidator, no suit or other legal proceeding shall be commenced, or if pending at the date of the winding up order, shall be proceeded with against the company, except by leave of the court and subject to such terms and conditions. So, my lord, if I have a claim, I'm staying outside winding up, I want to enforce, my lord, my security independent, I still have to come to court. Kindly see 2. My lord, the court shall, notwithstanding anything contained in any other law for the time being in force, have jurisdiction to entertain or dispose of any suit or proceeding by or against the company. Earlier days, my lord, when there were no specialized tribunals, my lord, a civil court decided this issue. My lord, the court could transfer, my lord, the suit to itself. So, my lord, let us say I had, my lord, a mortgage suit as a secured creditor, which was, my lord, in, my lord, the High Court of Bombay. Court could transfer it, my lord. Why? Because, my lord, it had jurisdiction under this. My lord, it was a High Court. And, my lord, it would save the liquidator costs of traveling and engaging, my lord, lawyers outside Kolkata. So these were conditions, my lord, which were imposed. Similarly, my lord, in a 446 transfer, my lord, petition or, my lord, leave to proceed, court could examine, my lord, the nature of the claim. If it was pointed out by the official liquidator that this is absolutely frivolous, that would be the end of the matter. Court may not grant leave. It had that discussion. So, my lord, whether I stay outside winding up or I stay within, my lord, I'm still a party to the proceeding.
Yes.
Now, my lord, kindly note, my lord, one thing. My lord, 457 under the old act. The liquidator, in a winding up by the tribunal, shall have power with the sanction of the court. This is to institute, defend, etc. And, my lord, B, my lord, kindly note this, to carry on the business of the company so far as may be necessary for the beneficial winding up. So, my lord, if, my lord, a beneficial winding up, my lord, is, my lord, I don't, my lord, hand over management to anybody else. My lord, I have to, my lord, do it so that what I put up for sale has value. So, my lord, if, my lord, the company is actually doing good business, but it's still wound up because of inability to pay, I will try and continue the business as long as possible so that, my lord, it actually, my lord, fetches a good price. It has to be in aid of winding up, not to stall it. Then, my lord, to sell immovable so-and-so, then to sell whole of the undertaking, etc. Now, my lord, kindly come to, my lord, 458. My lord, 457 starts with sanction of the court. 458, my lord, the court may by order provide that the liquidator may exercise any of the powers referred to in subsection 1 of section 457 without the sanction or intervention of the court, provided always that the exercise by liquidator of such powers shall be subject to the court. So, my lord, the liquidator may apply saying, please allow me to carry on this, or the court may itself provide in the winding up order that the liquidator can do all this. But ultimately, all action is subject to superintendence and control by the court. Because at the end of the day, my lord, a winding up court protects the interests of all creditors and contributories. My lord, it may not permit, my lord, an undervalue sale, even if I'm outside the winding up. Because the jurisdiction starts from 446. When it gives this permission, my lord, for me to proceed, my lord, in my lord, realization. I'm sorry.
For my education, you decide to stay totally theoretical,
correct.
hypothetical, outside the winding up. You stay
Yes.
outside the winding up. You obtain leave, you file a suit, let us, to enforce security.
Yes.
The security value has fallen, not enough to cover your dues.
Yes.
So after enforcing the security, can you not come and participate?
I can.
This is
That's the next point. My lord, I can. Correct. And my lord, I get to, my lord, participate, my lord, in, my lord, whatever assets, my lord, it makes no difference whether my lord, the only thing is when I stay out, I'm not subjecting myself to a court sale by the official liquidator apropos my security. That's all. Now, my lord, I'll give your lordships another example. My lord, with the passage of time, my lord, we've had an act which, if kindly permit me, my lord, to refer to it as surfacing. My lord, I don't need the intervention of court.
Correct.
My lord, I can, my lord, if it's a non-performing asset, my lord, move with surfacing, section 13 procedure. Ultimately, if, my lord, the company is not happy, my lord, with the steps I've taken, if I have, my lord, fallen foul of any provisions, my lord, go to, my lord, the debt recovery tribunal. These are, my lord, specialized statutes, which is why there's a line of cases that 446 leave is also not required for them. But, my lord, at the end of the day, if I've not recovered, my lord, what my dues are, let us say it's 1,000 crore today. I've exhausted my securities. Doesn't prevent me, my lord, from then coming back. And, my lord, claiming, my lord, in, my lord, the surplus if there's any. Contributories come last in the priority. So, my lord, this is all that it is. It's not some magic, my lord, statement that I will stay outside. And therefore, my lord, my lord, will have no part to play, my lord, in the winding up process. No, the greatest of respect. My lord, that I am not a party and therefore I could not have made the application. I'm sorry, my lord. This is, my lord, covered, my lord, by, my lord, the section itself, specifically, my lord. Section 447. And then, my lord, whatever steps are taken. My lord, your lordship recall those sections which says that there cannot be any change in shareholding. Or, my lord, the assets after an order of winding up is, in fact, after the admission, in the course of winding up. My lord, when I say I stand outside, I come and take leave of court saying, look, even though the winding up petition is pending, it could result in a winding up order. You please allow me to sell my assets.
Is there an equivalent of 447
Yes.
in
I'll show.
New
In
Act?
fact, today, there cannot be winding up also. Because everything is, my lord, IBC now. Now, my lord, I'll show your lordship, my lord. Kindly take, my lord, similar section I'll show. My lord, kindly take section 278 of, my lord, the 2013 Act. Fine.
Same.
Yes, I'm also continuing, my lord. I'm not stopping here, my lord. 278 shall operate in favor of all as if it had been made out on the joint petition. Then kindly see 279. When a winding up order has been passed or no suit shall be commenced or if pending shall be proceeded with by or against except with leave of and subject to such terms. Provided that any application seeking leave under the will be disposed of within 60 days, then nothing shall apply to any proceeding pending in appeal before the Supreme Court or a High Court. And my lord, since my lord, this was my lord before, my lord, the act came in, my lord, these winding up, my lord, proceedings, and my lord, the order of winding up was yes. So my lord, to page 251, 6th March 2017. That's my lord, while 2013 is there, my lord, the order of winding up is passed. 251, my lord, off, my lord. Inno Wagons appeal, my lord, page 251.
March.
Yes, my lord. My lord, 6th March 2017. First show 6th March, no? Don't jump. The winding up order, then appeal, whatever, my lord, I'm not, and then installment payments and all that starts. The old view is once it's acquired a representative character, my lord, no payments can be made to my lord creditors. Here, of course, the courts approved certain payments because it's a representative proceeding. There can't be any preference. But orders have been passed. I'm not going into it, my lord. Whether they are nullities, whether 900 rupees will come back or 9,000 rupees will come back, my lord, all that's immaterial. And I'll show your lordships, my lord. So, my lord, these are, my lord, as if, my lord, because of the repeal provisions here, my lord, 460, I think 460, 2A, my lord, as if it's done under the provisions of this act. That's, my lord, of the 2013 act, your lordship will find 465. I have it. My lord, the intention of the legislature, my lord, is very important here. But kindly have a look at this and I'll come to that. My lord, 465(2). Notwithstanding the repeal under subsection 1 of the repealed enactments, my lord, Companies Act 56 being one of them, anything done or any action taken or done or taken, including any so-and-so, operation, direction given or proceeding taken or any or so-and-so shall in so far as is not inconsistent be deemed to have been done or taken under the corresponding provisions. So 2013 also, your lordships asked the question, my lord, same impact. Same impact. Now, my lord, all these have been considered, my lord, in my lord cases. So, my lord, I wish to start with, my lord, Caledonia. My lord, that's, did Mr. Mithro cite this? 2021. My lord, I could go, my lord, is this the first one? Which is the first one, date-wise? My lord, before this, yes, just tell me the order. My lord, no. Jaipur Metals is the first one. Just check. Yes. My lord, there have been, my lord, I think six decisions of the Supreme Court. And my lord, I'll just place those. My lord, after that, my lord, there's no question of retaining it here. Because one principle, my lord, is, my lord, the change, the substantive change in the law. My lord, earlier, my lord, if a company would become commercially insolvent, my lord, the management remained till, my lord, the order of winding up was passed and the official liquidator took over and then dealt with the assets. Now, my lord, the IBC, my lord, does not, my lord, allow the management to continue. Once there is a default, we have a resolution professional who takes over the management. That's number one. Number two, my lord, liquidation is the last resort. My lord, first is, my lord, attempt at revival. Keeping away, my lord, the defaulters, 29A, my lord, they cannot be a, my lord, parties, a resolution applicant. Because of you, company has today gone into this insolvency. We are trying to maximize the value and by revival. So, my lord, the NPAs have to be set right. So, my lord, there is, my lord, a resolution plan. And, my lord, management is out. Resolution professional, my lord, is doing, my lord, all that's necessary. Suspended board, my lord, can attend committee of creditors meetings, but cannot, my lord, participate.
Generally, who are these people? Chartered accountants, etc.
Yes, my lord, from, my lord, and now there's a my lord, examination and a certificate and license given, my lord, to resolution professionals. Lot of them, my lord, are, my lord, part of, my lord, big audit firms. Some are therefore small, depend. So, my lord, the selection is done, my lord, by the financial creditor as an interim resolution professional. So, my lord, depending on what their claim is, my lord, they decide on who should be the resolution professional. Because once it gets admitted, Section 14 moratorium, an interim resolution professional is appointed. Then, my lord, the committee of creditors is constituted, my lord, which is the financial creditors. Operational creditors get a say only if there are no financial creditors. And, my lord, the suspended board stands suspended. My lord, they have, my lord, a place, my lord, to, my lord, attend, my lord, meetings of committee of creditors. That's about it, where they're expected to make fruitful suggestions. Now, my lord, in that, my lord, scenario, my lord, what happens, then they decide. My lord, claims, my lord, are invited. My lord, they are, my lord, admitted to whatever extent, but Supreme Court has held that that is not an adjudication. That's just determining for the purposes of the share in the COC and what would be the provision regarding operational creditors, because now, my lord, it's higher of the two, liquidation value and, my lord, not a key test, liquidation value, it's not operational creditor, minimum payment, liquidation value, and whichever is the higher as per the section. My lord, earlier the law was only liquidation value. So if liquidation value is zero, after going through waterfall mechanism, operational creditors got nothing. Now, my lord, there is an amendment, my lord, which gives operational creditors, my lord, something. No. My lord, there is, my lord, whichever is higher. My lord, I'll and they have to be paid first. They get priority. Why are you giving me section 52? My lord, section 31, 30. Yes, my lord, operational creditors shall be not less than the amount, my lord, to be paid to such creditors in the event of a liquidation, and, my lord, if they had been distributed in accordance with the priority in 53. So, my lord, whichever is higher, my lord, is, my lord, to be given. My lord, under liquidation value, my lord, if they're actually getting more, my lord, in the its resolution plan is higher than, my lord, the liquidation value, my lord, the entire investment, then of course they'll get more. by following the waterfall mechanism. So, my lord, this is the protection which, my lord, operational creditors have. But at the end of the day, my lord, this is how, my lord, they proceed. Management is out from the day it is admitted. Unlike the old regime, where they stayed till, my lord, a final winding up order was passed. So, first winding up order, then appeal, second winding up order, then Supreme Court. And in between, my lord, applications for stay under 466, my lord, part payment, Bodonagar was, my lord, the famous case. Then ultimately our High Court said 466, my lord, has to fulfill several conditions, and there cannot be a scheme under 466 which is not compliant with 391. My lord, it's a division bench headed by Justice Rumapal. I have all that, my lord, but my lord, the most important thing is, my lord, that, my lord, I am a party. Therefore, I can make this application. Because otherwise, nobody is a party, not even the company. It's only the petitioning creditor. It's because, my lord, it inures to the benefit. Advertisement, my lord, gives it, my lord, a representative character. That, my lord, all creditors and contributories become parties. And why them? Because they get to participate, my lord, in, my lord, the distribution of assets, the sale proceeds arising out of sale of, my lord, the assets. That's why it is, my lord, to their benefit. Even if I stand outside, if I don't recover, I can come in and join again without security. My lord, similarly, workmen who are treated, my lord, at par.
So you come in as an ordinary creditor.
I'm grateful. I may not get anything, but I'm entitled to participate. I don't go now, my lord. Have you got it date-wise? My lord, kindly take, yes, kindly Jaipur metals first, my lord. My lord, this is, my lord, 2019. Yes, my lord, this is 2019, 4 Supreme Court cases, 227. Now, kindly have a look at this, my lord. This is very important. If you got it, I will give Jaipur, no? 2 copies. Give the other side a copy. My lord, this was decided on 12th December 2018. Now, my lord, so now, my lord, what is important, my lord, is my lord, 4 principles, my lord, are, my lord, clear from this case. First is, my lord, a winding up petition cannot continue if a section 7 has been filed. I'll show that, my lord, from this judgment. And, my lord, there is a discussion, my lord, on, my lord, the transfer rules. Because rules cannot, at the end of the day, my lord, override the statute. Rules were, my lord, the notifications were being issued because of the power given to the central government. But once a proviso comes in, my lord, which, my lord, comes in place, my lord, the rules, my lord, cannot, my lord, apply at all. And, my lord, this dealt with, my lord, the Sikh Industrial Company Special Provisions Act, my lord, section 20. Now, my lord, kindly take para 11, my lord, first. In fact, my lord, I should, my lord, place a few more paragraphs. My lord, kindly take paragraph 1. The present appeal, my lord, kindly see, has been filed by an employees union challenging the judgment of the High Court of Judicature for Rajasthan, dated 1st June 2018, in which the High Court has refused to transfer winding up proceedings pending before it to the National Company Law Tribunal and has set aside an order dated 13th April 2018 of the National Company Law Tribunal, by which order a financial creditor's petition under Section 7 of IBC has been admitted. So, my lord, two things happened. Refused to transfer, and my lord, Section 7, my lord, was knocked out. Now, my lord, kindly take, my lord, 7 lines from the start of para 2 on 26 September. Your lordship has the.
Yes.
On 26 September, the BIFR was of the prima facie opinion that the company ought to be wound up, which opinion was forwarded to the High Court. The High Court ultimately registered the case as company petition number so-and-so. The Alchemist Asset Reconstruction Company, respond number 3, acquired substantially all the financial debts of respond number 1. The state of Rajasthan tried to revive the company, but with no success. Ultimately, in a writ petition filed by a workers' union being so-and-so, the High Court on so-and-so directed the official liquidator to be provisionally attached to the court and to join in evaluation of value and material lying, etc. In the meanwhile, respond number 3 preferred an application under Section 7, stating that it had an assigned debt of 356 crores owed to it by respond number 1, considering the fact that the debt was admitted by the company and that till date, now kindly note this is the difference in fact, no liquidation order had been passed in the winding up proceeding that were pending before the High Court. NCLT held, referring to the non-obstante clause contained in Section 238 of Insolvency Code, that it satisfied the conditions of Section 7 had been fulfilled and therefore application should be admitted accordingly so and so. Then, my lord, kindly come to, my lord, paragraph 4. My lord, NCLT order, my lord, challenged, etc. Then, my lord, kindly take paragraph 5. My lord, direction, my lord, given, my lord, for transfer. And kindly come to the submission, either transfer, alternatively, kindly come to 230. Alternatively, they argued that in any case, 2018 amendment made to section so-and-so added a proviso by which any party to any winding up proceedings that are pending may file an application for transfer, and the court is then obliged to transfer such. They also argued that in any case, a 7 application made by was an independent application which was correctly admitted, which correctly applied 238. Your lordships would recall, my lord, section 238. My lord, it is, my lord, the, my lord, non-obstante, my lord, I'll just show your lordships, my lord, the IBC, section 238. Copies. Lordships have copies, my lord, of the IBC. My lord, kindly see 238. My lord, this also has to be considered, my lord, in the context of this application. My lord, kindly see provisions of this code shall have effect, notwithstanding anything inconsistent therewith, contained in any other law for the time being in force, or any instrument having effect by virtue of any such law. Now, my lord, kindly take paragraph 10, page 231. It says, my lord, amendments to, my lord, the section 255 of the Insolvency Code reads as follows. The Companies Act shall be amended in the manner specified in the 11th schedule. In pursuance of this section, the 11th schedule of the code made various amendments. On 15 November, with effect from 1st December, section 434 was substituted as follows. Then, my lord, para 11, on and from 17th August, kindly mark this date, my lord, 17th August 2018, by an amendment made to the 11th schedule to the code, section 434 was substituted as under. My lord, this is the present position. First was 2017, then, my lord, 2018. My lord, next Wednesday, if it commences, your lordship, I don't know, my lord, whichever day. Friday is a holiday, my lord, I'm told.
What do you mean you're told? It is already.
I don't know, my lord, whether it's dependent on the sighting of any moon.
Never doubt holidays. 8 তারিখ
আমার ইয়েটা আছে না
9th or 11th.
Because it doesn't want holidays, my lord.
ঠিক আছে 9th ঠিক আছে
9th or 11th as it suits you.
ঠিক
Oh, not 11th, 9th.
11th would be 9/11.
my lord 9th না 9th কালিঙ্গা আছে আমাদের দুপুরে কোথায় আছো my lord could it be my lord the 10th or 11th my lord
10th.
হ্যাঁ আমি আছি my lord কালিঙ্গা আছে না সেটা প্রবলেম আমি বলছি তো
এখানে 12 তারিখটা ছুটি দেখাচ্ছে না কেন? 12 তারিখ তো ছুটি নেই দেখো বেটার ব্যাপার। হ্যাঁ, হ্যাঁ। 12th.
12th is right 12th ঠিক আছে তো
We'll keep it at 3 o'clock to be on the safe side, considering that it is a Friday.
yeah that's okay ঠিক আছে
Oh, bench. Oh, Friday, second half. Then 15th.
yes
15th, 3:30. Ki. Likhe now. Mr. Choyan Gupta, learned counsel representing Indo-Wagon, concludes
16th আছে
the opening submission on behalf of Indo-Wagon.
16th
Paragraph. Mr. Mukherjee, learned senior counsel representing Edelweiss. পুরো নামটা দেখে না Edelweiss, huh? Begins his argument but does not conclude. Paragraph as agreed by and between learned advocates for the parties. List this matter once again on Koyullam, September 15. You will finish in an hour, Mr. Mukherjee, or shall we?
my lord kindly give me 1.5 my lord I'll my lord
3 p.m. Mark 3 p.m.
তো তাই বলেছে ভোডাফোন কি নেক্সট সোমবার হবে my lord only one thing my lord one matter my lord my lord the Vodafone matter my lord
Yes.
my lord which is in the list my lord I'm only available my lord in the mornings my lord on days my lord on next Monday হ্যাঁ তো কালিঙ্গা আছে I'm just my lord
If you are not there, we'll not take it up.
The only thing is,
Oh, I see. I see.
size, my lord, adjournment. has
no
been
no I
taken
am
by-
not asking for I'm only saying kindly take it up in the morning
Because we have, my lord, people coming down.
So
every
do
day
I.
from Delhi,
my lord so do I my lord have my lord
এইটা কবে দেখি
আমি রাজি আছি বাট মর্নিং
Next Monday, what we'll do, your Vodafone is number 123 under appeal from orders. Next Monday, it will appear before specially assigned matters so that it is taken up first.
grateful to you.
Then your gas will have to. Next thing, next item. You're also in Vodafone.
Yes.
his my lord benefits and my lord in the afternoon
arguing, my lord,
and my lord in the afternoon he's on my other side
First mobile phone, then gas. So